Yes.
Instruction of our client, we will not take this.
Ms. G. Bora, the Learning Council appearing on behalf of the petitioner, submits on instructions that the petitioner would not like to press the instant petition. Accordingly, the petition stands closed on withdrawal. Interim order, if any, stands vacant. Yes. Hmm. Then what do you do with the limitation? There's no limitation. If you don't press it, then you have a problem. So let the matter be taken up. I will dismiss it on the ground of appellate forum and be giving you the limit. I think that is better. May not be taken up today. Okay. Why? No, it's okay. Why the matter has come up? For orders? Why? We will pass the effective. Understood. The effective orders requires to be passed. So let me pass the effective orders when the matter is come. Yeah, I won't do anything which will be prejudicial to you. But if for orders, if we don't correct it, then it will again come up another year. Yes, next. 20. No stay. The request of the Learning Council for the petition of matter stands adjourned to be listed after the Puja vacations. 20? Oh.
In this matter, we are required to file that with the opposition side will respond and sometime.
You got to stay. At the request of the Learning Council for the petition of matter stands adjourned to be listed after 6 weeks. In the meantime, the petitioner will be at liberty to file their reply.
We have filed a replacement application for the incumbent.
In
item number 40 to 47 in your option, we have filed a replacement application to replace the new respondent. Along with the eyes are also.
Eyes are here.
Eyes are not.
How do I take up? Eyes have to be listed. Why the matters have been listed today?
File a replacement application to any incumbent. We have filed that eyes not. She cannot have not come out.
There is some eye of 2018. No, these are not relevant. Item 40 to 47. The Learning Council for the petitioner submits that there has been certain applications filed in the batch of contempt applications seeking implement of the new incumbents. As the said interlocutory applications are not on record, this matters after the purifications. The respondent, the registry shall bring on records the state interlocutory application. The order to do. Withdraw. In time order, it is specific. Why? Who is your senior? Okay. Have you paid the court fee for 79 people? I'll assume it. But if you have not paid, we are going to pay that. And then we'll have it on some other. Tonight I'm doing a favor for you people. Non-receipt of compensation. Okay. That's it. People could hear. It appears that there are 79 petitions claiming their individual right to compensation on the basis of certain acquisition of land made in their on the basis of certain acquisitions of their lands by the respondent authorities. Under such circumstances, each and every petitioner has a distinct cause of action. However, it is seen from the records that the court fee of only one petitioner has been paid. The learned counsel appearing on behalf of the petitioner submits that the remaining court fees shall be paid, the deficit court fee shall be paid on or before the next date. Lists the matter on 10th of November. In the meantime, the court fee be Who wants to be pleaded?
I'm the actual owner of the land.
Oh. And what is the petitioner asking?
They have the complaint law for
Let him say it is his application. Won't you allow him to even say something? Yes.
for
What is the petition asking?
now what and they are inquiry, they are inquiry regarding the for the land.
Enquiry of a plot of land.
They have complaint. Complaint that they are seeking for the
An inquiry. And how are you aggrieved?
okay. And since I am the actual owner of the land,
So,
I am not with the actual party responsible.
how are you going to be affected?
If I was not passed
Advance means they are only asking for an inquiry to be made. They will inquire after giving you notice. Then how are you affected?
apart from that inquiry, there was another PR was there.
Hmm. Because the moment here you are, there is a direction upon the state information Assam to provide the land documents pertaining to the plot of the petitioner as sought for. You are saying that you are the owner of the land. So if they don't make you a party, can this court direct? Then this court. So if you are you trying to help the petitioner? Mr. Counsel, I'm trying to help the petitioner because the moment you are inside, it becomes easier for him to get it.
It's also relative all the, they have been with some relative,
Complied with. Fantastic. If that be so, kindly change your positions. Let me hear him. Yes, Mr. Adar. You may dispose of the matter. You are responding with the petitioner. Huh? Yes, the main person is you. Mr. Pinayak, you are the main person. The inaction of the GMD. Yes, tell me. Is that? 23, yes. What is the name of the petitioner? Boris Injal. Then
Number 6.
6. Okay, K6 construction. Then
Then, I filed for one application for revocation of building permission. My data is 5/4/2022. But my petition is pending at GMD even after 1.5 years. What we kindly see case number 32 NX of 4.
yes, prayer for revoking the building permission, and it is pending before him.
Yes.
Then
Then also the process, the psychological consider one in this case who altered a land record. We can notice the practice case number 56 NX of 12.
56. Yes,
Whereas the same psychologist is saying that records are not available with him. Okay, but on
who is Ankur Datta?
Case number.
This notice has been issued to you also. Yes. This is to inform you that on an application while a miscase has been registered for correction of the land record, there is a requirement of hearing in the miscase, hence on so and so is fixed. Hence on the fixed date, so and so undersigned along with you being present. Then what happened?
There is a inquiry by ordered by deputy commissioner on revocation of production against the government officers on 9/9/2000 to be conducted by the ABC. Respondent of 4. Notified by on 2018. 2018. But no.
Huh?
No significant filed by.
No, how are you, what is your case? Your case is that a permission has been given to respond number 6. You agree only with that. And what else is required from you? Have you asked for any cancellation, anything else from anybody? So your basic case is the JMDA have not acted on the particular permission, your application for revoking that. That's all. Yes, Mr. Naik. We'll look in first, let him. 33. Yes. No, page 33 is before the chief executive officer.
And the prayer was his application for a speedy disposal of this application. On the basis
Hence,
of-
it is requested to take steps for revoking. No, his prayer was for revoking.
Yes, for revoking and his prayer for that complaint dated 5/4/2022 in a reasonable time call may or not. Disposal of the complaint.
No.
On the basis of-
No, Mr. So like page 33 of the petition
It's
is a complaint to the chief executive officer
by the
by the petitioner for revoking the building permission.
Permission granted.
Yes. What have you done on this?
And is fair on for speedy disposal of that complaint. Now, Lordship, in the meantime, Lordship, on last day also I submitted to the Honorable Court. In respect of the same clause of that, one proceeding was given to the second one. And the circle of side in the meantime, that is that.
Regarding that he is not the owner.
Yes, against,
Where is that?
the federal officer final report and that order is. And on the basis of that report, that in the meantime, we should not stop construction which is started. Now that has to be withdrawn.
So this was the stop construction notice on 29/5/2023.
No, this was the vacation of the stop construction.
Yes.
By this.
Withdraw. On the basis of
This
the
report
commission
has
and
given
then
to the-
applying to the complaint against the petitioner for indulging in corrupt practices on the basis of the complaint by swear to by permission of the Who is Ankur Datta?
Ankur is the petitioner, my lord, who is seeking infringement now. That is why, here, my lord.
He.
That is why I conducted my lord to clear the proper fact, you know, lost it, my lord.
No. So, Mr. Counsel, what happens out here is the only way out is to file a civil suit. You say that you have a right over the land. The authorities made an inquiry and found that no. So you are to prove your right over the land on the basis of a suit. Isn't it? Otherwise, your petition is useless. You have asked for a speedy disposal of 5/4/2022. That has already been done by them. This is the order. Second is you have asked for an inquiry report. The inquiry report has already been done to the effect holding that no, you have no right. It is Ankur Datta who has right. So if your only way out is to challenge it. Don't you think so? Unless you show your title, can this court decide you have a title over the land? No. So the only way out is to file a suit and get an injunction against the respondent number 6, showing that you have a land. Don't you think so? I'm helping you more than whatever is necessary. Okay. This is an application filed by the applicant seeking impleadment as the respondent number 8 to the instant writ proceedings on the ground that the applicant is the owner of the land in question, wherein in respect of which the petitioner claims to be the owner. So, taking into account that the presence of the respondent, the applicant would be necessary for a proper adjudication of the writ petition, the said applicant is arrayed as the respondent number 8 to the accompanying writ petition. The respondent the registry shall make necessary correction of the records and update the same in the CIS. Very good. That is one. I accordingly send this. The absolutely. In view of the order passed in I number so and so, the respondent number 8 have been included. While taking up the matter, it has been brought to the attention of this court that the writ petition filed by the petitioner had already become infructuous, taking into account that the relief which has been sought for have already been addressed to by the concerned respondent authorities. During the course of hearing, this court at this stage finds it relevant to take note of that the petitioner claiming to be the owner of the plot of land, wherein the respondent number 6 have been granted a building permission. Respondent number 7 have been granted a building permission. Had lodged a complaint before the Chief Executive Officer, Guwahati Metropolitan Development Authority on 5/4/2022. It is on account of the inaction on the part of the authority under the inaction on the part of the officials of the Guwahati Metropolitan Development Authority that the petitioner had approached this court by way of the instant writ petition. It is also seen that that simultaneously another proceedings was initiated before the circle officer, Guwahati Revenue Circle, Dispur Revenue Circle, as regards the right over the land in question. The record further shows during the course of the hearing, it has been brought to the attention of this court that pursuant to the application filed by the petitioner before the Chief Executive Officer, GMDA, a stop construction notice was issued to the respondent number 7 by the order dated by the notice dated 30/7/2022. It is also seen that upon the inquiry being made by the revenue authorities, it has been found that the petitioner has no right over the land in question. Rather, the land belongs to the newly implemented respondent number 8. It is under such circumstances, the complaint which has been filed by the petitioner on 5/4/2022 was closed by the Chief Executive Officer, Guwahati Metropolitan Development Authority, thereby withdrawing the stop construction notice. The order dated 29/5/2023 was placed before this court during the course of hearing, and the same is kept on record and marked. It is the original.
I'll give a copy.
and marked with the letter X. Taking into account the above, the learned counsel appearing on behalf of the petitioner submits that the revenue authorities would have no jurisdiction to decide on the question of title. And as such, the findings which have been arrived at by the revenue authorities that it is the respondent number 8 has title over the, is the so absolute title holder over the land in question. Is totally, is not taken. Be that as it may, the question as to whether the petitioner has title over the land in question or whether the respondent number 8 has title over the question, over the land in question, cannot be adjudicated by this court. Under such circumstances, this court, in view of the order dated 29/5/2023, as well as the findings of the revenue authorities to the effect that the petitioner had no right over the land in question, dismisses the instant petition. Before concluding, this court, however, clarifies and observes that the dismissal of the instant petition would not preclude or prejudice the petitioner in initiating a proceedings, in initiating any appropriate of proceedings before the competent civil court. And the observations made herein above shall not affect the petitioner in such proceedings. Petition destroyed. Now, Mr. Counsel, I made you party also.
And number 2.
Yes.
My lord, the petitioner is the recorded owner in possession of the plot of land which has been acquired by the phone number 4 for National Highway. And the highway has already been passed that. But only details of the petitioner is that no notice has ever been served on the petitioner, no compensation has been paid. I may be allowed to file a detailed representation to the phone number 2. Who may be directed to the court of the same case. Earlier, I can't representation which is not there.
You are the owner.
Or, my, the only is at page 8, my lord, the 11th person. Name is there at the serial number 25.
Hmm.
There is 9 is the barnacle of.
When was the acquisition done?
Collector.
Who has done the acquisition? How do I know? Acquisition for under what provision?
I don't know, because no notice was ever served. Only possession has been taken, but under which provisions of law, there are.
No, whether there was at all an acquisition or not, how do I know?
That's why they also find.
So do you,
Affidavit, my lord.
no, who has taken the land?
This one of four, the National Highway Authority.
And why have you made the National Highway Authority of India just as there, where is the address? Nothing? What is this type of petition?
But it is start to their.
What standing counsel it has been served? How can you have it in this manner? Is this the manner in which you prepare a petition? Land Acquisition Officer, Hailakandi. National Highway Authority of India. Who is this Sarafat Ali Bordhuya?
It is in his name, it has been recorded. Before the concern of the. The Land Acquisition Authority has to pay the fee, not me.
So they paid him in respect to the land?
Yes.
Not you?
No.
Have you approached them?
Yes.
When? Where?
My representation was,
Oh, not this. Where's your representation? Is it your land?
my land because someone is there, it's a agent,
No. Whose land it is?
and it's mine.
This is a legal notice out there.
Yes.
No, have you approached the authorities before whom it is done?
You want to collect that?
Collector. Was it, therefore, the question will arise, was it done under the Land Acquisition Act 1894,
That's right.
under the 2013,
Yes.
or the National Highways Act?
I meant to that under no law, any notice was passed. Either under.
How do you know that the other side has got money?
Only with her, which is, on part of the payment has been made. The remaining part not yet made.
No. From a perusal of the materials on record, this court is however not satisfied. On perusal of the records, this court is not satisfied that the petitioner have disclosed the required material facts for initiation of proceedings under Article 226. Be that as it may, this court directs gives the liberty to the petitioner to file an additional affidavit bringing on record certain the material facts on the basis of which this court can entertain the petition. List the matter after immediately after the Puja vacations.
And you also allowed to give the correct address for the.
You do whatever you know how it is. Why should I say all this thing? You have to file an application. You can't make it in this manner. You have to say better particulars. What are these particulars? Because on the next date, if this matter comes before me and you don't file your additional affidavit bringing on record this, I'm going to dismiss. Yes, what is this case? Yes, madam, any idea on this aspect? You have produced a copy of the report dated of the Deputy Commissioner indicating progress made in the investigation connected to the. Yes, where is the report? Where is the report? You have information? What is it? Show me. This is of 2016 FIR. Has it been charged sheeted till now? Or yes, got it. Before registration, after getting the information about the decision during investigation, the information had the CDR mobile experience collected the Facebook. From the records, it is revealed that on the basis of an FIR, the Pragjyotispur PS case number 75/2016 was registered under section 120B/365/34 of the Indian Penal Code. It is also seen that there has been certain investigation carried out in respect to the said Pragjyotispur PS case number 75/2016. The instructions which were produced dates back to the months of October and November 2019. List the matter again on 29. List the matter again on 4th of October 2023, on which date Ms. S. Borua shall apprise this court as to what has happened thereafter and update on the progress of the investigation. None appears on behalf of the petitioner on call. It is also seen that the petitioner earlier also had not appeared. Consequently, the petition stands dismissed for non-prosecution. The instant petition has been filed by the petitioner seeking a direction upon the respondents to allot the plot of land in which the petitioner along with his family have been residing for more than 20 years as per the land policy of 1989. This court, the learned counsel, Ms. S. Purva, the learned counsel appearing on behalf of the respondent authorities have drawn the attention of this court to the land policy of 2019 of the government of Assam. Under such circumstances, this court is not in a position to issue the writ as has been sought for. Be it as it may, from a perusal of the affidavit filed by the respondent number 1, 2, and 3, it is seen, it transpires that the land covered under DAG number 225, wherein the petitioner have stated to have been occupied, is a parcel of land reserved for the central jail. And the government, by the order dated 4/10/2013, allotted a total of 56 bighas, 2 kothas, 5 lechas of land of village Sohor Guwahati Part 2 in favor of the Guwahati Metropolitan Development Authority on resumption from the Home Department for utilization of the old jail complex land in the way as stated below. Number 1, 80% of the total area to be kept as open greenery space. The subsurface area of the open greenery space is to be converted to an organized and scientific parking area. Number 2, on the southern area end next to the railway track, 20% of the total land is to be reserved for creation of multi-story and multi-purpose buildings which can be used to house the police outpost, a fire station, disaster response center, and a hospital cum trauma center. Roman 3, facilitating for landing of helicopters in the park area to facilitate airlift of critical cases during emergency. And number 4, the land shall not be transferred or leased out to any other organization, body, institution, individual, etc., without permission from the Revenue and Disaster Management Department. Under such circumstances, the question of the petitioner being, in view of the specific stand taken by the respondent number 1 and 3 in their affidavit, the question of the petitioner being allotted the land under their occupation therefore does not arise. Consequently, this court therefore finds no merit in the writ petition for which the writ petition stands dismissed. Be that as it may, the petitioner would, if the petitioner is eligible as per the land policy of 2019, would be at liberty to apply for allotment of land, and the dismissal of the instant writ petition shall not prejudice the rights of the petitioner. This is this land, Mr. The Fancy Bazaar land. The instant writ petition has been filed by the petitioner being aggrieved by the inaction on the part of the police authorities in carrying out the investigation pertaining to Kharubaita PS case number 365/2017. Taking into account the judgment of the Supreme Court in the case of Sakira Vasu versus so-and-so reported in so-and-so, the instant petition is not maintainable. Be that as it may, this court, however, finds it relevant to observe that from the materials on record, it transpired that the investigation had been carried out. And this aspect of the matter has been duly reflected in the order dated 29/11/2017. Accordingly, nothing survives in the writ petition for which the writ petition stands closed.
2008 US
Page
409.
And number 8.
The learned counsel appearing on behalf of the petitioner submits. The instant writ petition has been filed by the petitioner challenging the inaction on the part of the respondent authorities in not making payment of the compensation as per the OM dated 18/12/2013 for the death of his wife. In spite of various representations being submitted to the respondent number 2, 5, and 7. The learned counsel for the petitioners during the course of the hearing submitted that as there is an appellate forum, he would not like to press the instant writ petition. He, however, submits that the withdrawal of the instant writ petition should not prejudice the petitioner in his while approaching the appellate forum. The learned counsel further submitted that as the petitioner was bona fidely litigating before this court, the period during which the instant writ petition was pending litigation before this court on the basis of wrong advice, the period during which the instant writ petition was pending be excluded while computing the period of limitation. Taking into account the above submissions, this court, taking into account the above submission and also taking into account that there is an appellate forum. Appellate forum is there before,
For the AERC, Assam Electricity Regulatory Commission.
before the Assam Electricity Regulatory Commission. This court permits the petitioner to withdraw the instant petition and approach the appellate forum. It is also seen that on account of wrong advice, the petitioner has directly approached the court. And as such, the petitioner cannot be said to be at fault in the delay in approaching the appropriate forum, appellate authority. Under such circumstances, the period during which the instant petition has been pending, that is, from 6/11/2017 till date, that is, be excluded, both inclusive, be excluded while computing the period of limitation in filing the appeal.
Actually, the accidental report and infected report has already come. So now he has to challenge this. And for that, he has to go to the CTR. That will be Consumer Privilege Registered Forum. If he has to challenge this. Because my lord, we see that now it will come to question that whether he has to challenge the accidental report that is given by the chief electrical expert.
What does he say?
That says that it has been his fault.
Oh,
Yes, my lord.
then why you are saying this? You have the accidental report?
Yes, my lord. It is
Okay.
there by my lord.
Okay, okay.
Inquiry report is being filed 16/1.
Very good.
That is, the affidavit opposition filed by the respondent number 6.
Where is the accidental report? Huh? 40. Lahore. The instant petition has been filed by the petitioner seeking compensation from the respondent epidicial. On account of the death of the wife of the petitioner. A perusal of the petition reveals that it has been alleged by the petitioner that the wife of the petitioner on 27/7/2015, while walking in front of his residence at around 1:30 p.m. Suddenly, a high voltage wire fell down from the electricity post adjustment to her residence, for which the wife of the petitioner was electrocuted and accordingly she died. Post the said incident, the brother of the petitioner lodged an FIR with the Kokila police station police outpost, on the basis of which Kokila WP GDE numbers 422 dated 27/7/2015 was registered, was entered into, and thereupon the said FIR was forwarded to the Abhayapuri police station, for which Abhayapuri PSUD case number 17/2015 was registered. It is the case of the petitioner that an inquiry was made by the police officials by the officer in charge of Pulisa Kokila Police Watch Outpost. And the inquiry officer found that the wife of the petitioner died due to electrocution on 27/7/2015 at around 1:30 p.m. Thereupon, the petitioner have been approaching the respondent authorities for payment of the compensation on the basis of the office memorandum dated 18/12/2013. However, as no payment, no compensation was paid, the instant petition was filed. It is apparent from the reports that the respondents, respondent APDCL authorities have filed an affidavit in opposition. Denying the allegations made by the petitioner. It was a specific stand taken by the respondent APDCL authorities in the affidavit that the wife of the petitioner did not die because of a high voltage wire fell down on her from the light post adjacent to her residence, resulting in electrocution as stated in the petition. It was stated that on 27/7/2015, when the wife of the petitioner came to fill water in a bucket and touched a hand pump installed within the house premises of the petitioner, she got electric shock. The hand pump was located near the bathroom within the house premises of the petitioner. It was further stated that there was a leakage of electricity due to defective wiring, and the accident occurred within the premises. Under such circumstances, it was the case of the respondent APDCL that under no that the respondent APDCL cannot be settled with any liability. This court further finds it relevant to take note of the affidavit filed by the respondent number 6, whereby the inquiry report dated 16/1/2018 was enclosed as Annexure A. From a perusal of the said inquiry report, it is apparent that the incident which had happened, the incident which led to the death of the wife of the petitioner, was on account of an electric shock by coming into contact with the live metallic part of the hand pump system. In the said electrical report, it was also mentioned that the respondent APDCL was nowhere involved. Taking into account the above, at this stage, this court finds it relevant to take note of the AREC. What is that? No, that compensation scheme. What is the name? Here. Huh?
Page 31 of the.
No, you have that scheme now. What is that?
Scheme for composition for electrification. That is the office number 88.
This is the office. Where is that scheme?
Page 31.
This is the office memorandum. Where is the scheme? There's a scheme now wherein Schedule A, Schedule B, Schedule C is there. They are appearing without that scheme. Electricity, APDCL people. Asal এখন scheme এখন আছে না? I think that matter, who took that judgment? I Hussein was appearing and AP Pathak was appearing. Scheme. And this court at this stage finds it relevant to take note of that in terms with section 57 of the Electricity Act of 2013, there is a scheme formulated by the Assam State and Assam
Electricity Regulatory Commission.
Regulatory Commission, known as the Assam So-and-so Commission, victims ki baat hai. From a perusal of the scheme, it is seen that it is only the APDCL would pay the compensation as scheduled out, as mentioned in Schedule A.
I was scheduling for the accidents.
Schedule A, na? You are not aware.
So my lord is talking about the scheme with regard to the electrocution. My lord, that scheme is given by us, only, by the APDCL authority. itself.
Understood, but where is it? Schedule A or Schedule 1?
Schedule A.
The Schedule 1, A. That an amount of rupees 4 lakhs is paid as compensation only when it is the fault of the APDCL. From the materials on record, and more particularly from the electrical accident report, it reveals that there was no fault on the part of the APDCL. Under such circumstances, the questions of issuance of a writ in the present facts does not arise, for which the instant petition therefore stands dismissed.
Nine.
Yes.
I don't think it is because of the petitioner.
Ah,
Where tenants under Golpa certificate,
ah,
they were issued tenant certificate and paid 43 million. Panel for the
Mm.
11%. Particularly they paid 45.
Mm.
Now, the petitioner are occupying the sentence.
Mm.
After, by operation of law, my lord, under section 4 of Assam landholding adoption of relationship under the Assam Land and Revenue Regulation 86 in the acquired or permanently settled estate act 1970. By this act, the Golpara Agency Act was repealed and the petitioners are granted the status of tenant, having all rights of tenant under the Assam temporary area, settled areas finance act
mm,
and other laws. Now, my lord, the only grievance of the petitioners is that they were not given tenancy certificates or any social or they are not given recorded. So they submitted representation for recording that.
mm,
Representation is at page 101
mm.
for allotment, settlement, whatever it may be.
Mm.
They are protected by this act.
Then,
For the last 100 years, they are occupying this land. Now under their, since their names have not been recorded, so they are under threat of eviction. So they are there.
but is that your case in your petition? Your case is that you are claiming rights under the section 16 of the Assam Fixation of Land Ceiling Act. And that is a case where, when by way of a ceiling surplus land which becomes the government land, that can be allotted.
Since
That is a different case from what you are saying.
by abolition of dominion act, my lord, the land has been vested with the government. Now it is with the government there to settle under the ceiling act or under the land policy. We want settlement, allotment of settlement. That's why we submitted representation.
Then
This has not been responded. So we are comfortable.
who wants a settlement?
Petitioners want settlement and.
Which petitioner wants the
Deputy
settlement?
Commissioner.
Which petitioner wants the
all
settlement?
the petitioners. There are-
No. Only one petition.
No, but here.
One land will be enough. How much you entitled for settlement?
Here is their own behalf of other petitioners.
How many, how much land a person can get settlement? As per you?
One behalf.
So 1 bigger for the 78 people,
Yes, my lord.
1
Here-
bigger
here
for
only of 51 behalf. Involvement is about 51 behalf.
51 bigger. Now 1 bigger will be allotted,
So each of them.
no, to all the 78.
Yes, ma'am.
Okay,
78 behalf required by.
no, not 78 bigger, 1 bigger.
Yes.
1 bigger will be allotted, you share your among.
No, 1 behalf for each of them.
No,
As per the land.
1 bigger for entire 79.
It is not the end. There are several families, my lord. The original hotel holders also mentioned about several families. It is in the name of several persons. Now they are these persons are their successors.
They are the
These one-
purchasers.
Yeah,
First of all, let's see what is the right you are having. Let's see.
right under the section 4 of 1974.
Let us see. First, are you, what is your basis of your claim?
That it was, the land was under 1.10.
How do you say so?
The question says.
Where is the quotidian?
Page 43,
Page
43.
43. Yes. Quotidian number 1, description and occupier, government of Assam acquired Sopor and so estate. As per the order dated so and so by the SDC, the name of Somar Ali has been incorporated in the quotidian. Quotidian number 36, name, details, so and so. CT Act 119, reported rights. So you have a quotidian under what provision?
Under the provisions of DT Act, Golpar Tenancy Act.
Okay, then what is your right after the extinguishment of this Gwalpar Tenancy Act?
Right has been conferred under section 4 of 1974.
Let us see. Banerjee ki report. Nineteen?
74. Assam landholding, adoption of relationship under the Assam Land and Revenue Regulation, 1983. in the acquired-
Assam, wait. In which book? Where do I get it? Oh, you can. Volume?
Land laws of Assam by. Land laws of Assam,
Volume?
volume 1.
Yes, page.
Page 514. 514.
540, yes. Relationship, Assam landholding, adoption of relationship under the so and so in the acquired permanently settled. Okay, then,
Then 516 may be seen, my lord. But the Golpar Tenancy Act.
power to realize area, so and so conformment of landholder status to persons holding land under the government. Any person on the commencement of this act holding any land directly under the government in the area under which any acquisition of land shall continue to hold the same under the recognition of status of the person. And section 6. On and from the date of commencement of this act, the act mentioned in the schedule shall be repealed and notwithstanding of any rule made, any order issued, any notification public, any proceedings commenced, any action taken or anything whatsoever done under the act, so it shall continue and deemed to have been continually have been made, issued under the regulation until a settlement operation under the regulation is completed in the any responsible under the regulation. Yes, what are you referring to?
Like the 516 page, this doesn't say the government and the exception detail
Then,
by this act.
Hmm.
Then rights have been conferred under section 4 of
section 4 of what?
this 1974.
No. Section 4 will apply where?
When where the persons were tenant.
Where is it mentioned? Let us see.
Subsection 2. Every person holding land at an
Of another person in the area shall continue to hold the same with the status of a tenant as per the provisions of the Assam Temporarily Settled Area Tenancy Act. Then, so therefore, you become a tenant under the temporarily settled area
Yes.
tenant.
because of this.
So then you file your application under the provisions of the 71 Act for the purpose of granting ownership.
Yes, I know.
Where is that?
We should be given.
Oh, there. That is why I was thinking, why?
We have five representation.
No, no,
Uh,
no, representation won't do. You see, what happened by virtue of this act,
Yeah.
you become a tenant under the Tenancy Act of
Yeah.
71.
Yeah.
And if it is the Tenancy Act of 1971, there is a manner in which you are going to apply under the 71 Act, under the acquisition of ownership, under 21, 22, and 25. Then why you are not doing it? And why? How can you submit representation and look here, give it to me? And what is the right you are claiming out here? Under section 16 of the Assam fixation. Argument is different, application is different. Matter is different. And what you should do is also different.
we will be allowed to give the liberty to approach the competent authorities under 71.
You approach, that is the power which has been given to you. Huh? No. Yes, he has to give it before the deputy commissioner concerned by virtue of that. The learned counsel appearing on behalf of the petitioner submits that by virtue of section by virtue of the provisions of the Assam land holding bracket adoption of relationship under the Assam Land and Revenue Regulation, 1886 in the acquired permanently settled estate bracket close Act 1974. The petitioners who were the erstwhile tenants, were the tenants under the Gwalpara Tenancy Act 1929.
Their PDCs are what?
The petitioner or the predecessors who were the tenants under the Gwalpara Tenancy Act 1929 would become tenants under the Assam temporarily settled areas bracket close Tenancy Act 1971. The learned counsel for the petitioner submits that on wrong advice, the instant petition was filed, and on wrong advice, representations were submitted before the authorities concerned. Rather, applications under the provisions of the said Act of 1971 ought to have been filed for the purpose of claiming ownership over the lands under their possession. Yeah. The learned counsel for the petitioner therefore submits that the petitioner would like to withdraw the instant petition and approach the respondent authorities. He submits that the withdrawal of the instant petition should not prejudice the petitioner. It should not prejudice the rights of the petition. Taking into account the above, the instant petition stands closed on withdrawal. The withdrawal of the instant petition shall not preclude or prejudice the petitioner to approach the respondent authorities if so advised. In time order, if any, stands again.
But that was of 19, my lord, I am not a that. But even proposal, my lord, has been approved by the my lord, then a president, my lord, committee, my lord. My lord, we as part my lord, as part my lord, as part guideline, my lord, their proposal has been my lord forwarded in my lord government, my lord. Whether my lord the cancellation order by the deputy commissioner, whether the commissioner can cancel the order of the my lord approval proposal by the mayor.
It's not an approval, it's a recommendation.
My lord,
Who is the final authority to give you settlement?
my lord, government. Deputy commissioner, but that order has been my lord
Approved,
approved by the my lord.
government.
Yes.
Government has not given.
Government has not given. My submission is that my lord,
You have no right on the basis of that approval which have been approved, not approval, recommendation being made by the SDAC.
guideline, my lord, guideline of my lord, necessary committee, my
Hmm?
then my lord, government. It is a very complicated of the.
Where is the letter by which it has been rejected? Hmm?
7.5, my lord. Second paragraph. Considering property approved by the
3 bighas can be given. If you are having 3 bighas, an exception can be made. But you are having 36 bighas.
19.
Hmm? The person having more than 3.5 bighas of real will, however, be not entitled to the above benefit.
Okay.
Now, this is the policy. As of now, it cannot be given. The instant petition has been filed by the petitioner challenging the order dated 29/3/2018, whereby the land settlement proposal approved by the SDLAC Dhokwakhana held on 4/7/2008 in favor of the petitioner in respect to a plot of land measuring 1 kata 2 lachas covered by Dag number 15 of village Mohguli, Sapori. Sapori or Saponi?
Sapori.
Saponi. Saponi. And the Dhokwakhana Moja was cancelled. It is seen that it is seen from a perusal of the impugned order dated 29/3/2018 that the cancellation of the proposal, which was recommended by the SLDAC Dhokwakhana, was on the ground that a total area of land measuring 36 bighas 1 kata 3 lachas stands in the name of the petitioner. At village Boruatika under Dhokwakhana Moja. This court on 29/2023, when the matter was taken up, Mrs. P.R. Mohanta, the learned standing counsel for the Revenue Department, has drawn the attention of this court to the present land policy of the government of Assam, wherein, as per clause 14.4 a person having more than 3.5 bighas of land in rural area would not be entitled to be considered for settlement of land measuring 1 katha 10 lechas. This court had also duly taken note of the submission of Mrs. P.R. Mohanta to the effect that a recommendation so made by the SDLAC, Dhokwakhana, would not create an enforceable right in favor of the petition. And as such, the petitioner cannot claim any rights on the basis of the land policy of 1989, which already stood repealed in view of the present land policy of 2019. Under such circumstances, taking into consideration the land policy of 2019 and more particularly clause 14.4, the question of issuance of a certiorari to set aside and quash the order dated 29/3/2018 in the present facts does not arise. Accordingly, this court finds no merit in the writ petition for which the writ petition stands dismissed. Interim order, if any, stands vacated.
Where it was, citing by contract house.
Where?
Citing by contract house. Where it stated that it was in position.
Who is the competent authority to execute the law? So there is a land allotment recommendation being made in your favor in 2011.
Above 1 giga, but it cannot be allotted, so only 1 giga can be allotted. And there also.
Where is the land? Town? Town to now it cannot be given.
After 2019. 2019, half giga, but there's half giga version.
Happy? No. 2019 is, if it is town, it is one katha 10 lechas.
But they are deciding their version by constructing houses.
So,
And I have filed the 2019
so
proposals were already sent in 2010 and 2020.
no, but madam, show me your enforceable right on the basis of those things. The policy has changed. Once the policy is changed as of now, can there be a direction by this court to give you an allotment on the basis of some, because no right is accrued on the basis of your application. No, but tell me whether you are entitled to right over a land on the basis of the land policy or on the basis of the statutes. It is on the basis of the statute, doesn't say anything. Statute as well as the settlement rules. The regulation and the settlement rules only say that there would be a settlement can be made. That's all. But it is on the basis of the policy. The policy is not there, but can this court now direct that you consider the policy as it is then?
The proposal was sent the year 2019, why it was sent to the wrong person? why it was not considered as the persons were residing there since 2010 as per this application. I have annexed the application annexed to page 17. There are houses the person was residing, and now after this death person is treated as citizen. So if I after the logic, then each of the part after the or
Not half kata, 1 kata 10 lakhs.
after the logic, then each of the petitioners logic.
How many petitioners are you?
Petitioner died.
Huh? There's only one petitioner.
On the death of Priyadani Sundar, his legal heirs came from.
The legal heir doesn't mean that everybody will get more than that. My goodness.
7 petitioners were given.
There's no 7, there is only one petition.
Then one
And then from 1 it became 7. So, and from that, by the time I keep the petition pending for another 15 years, from that 1, 7, it may be 14. So are you saying that 14 cannot be given only 1 kata 10 lakhs?
land will also become 52 worship by that time.
Huh?
By another 15 years, then we worship it is the area of that zero worship. From 1 weekend it becomes 1 percent.
In fact, yesterday I was reading a judgment. Very pertinent judgment of the Supreme Court, where I think it is in Maharashtra, I suppose, there is a policy that conversion of agricultural land can be made residential if some portion of the land would be bequeathed by the owner for public utility. And that was approved by the Supreme Court yesterday. And it was said, yes, that is permissible. And then it is that area of the land can be, or the conversion was permissible. But anyways, madam, the thing is that you are only entitled to 1 kata 10 lakhs, nothing more than that. Because on the basis of whatever this SLDCA, this is only a procedure. Tomorrow you may, this is from SLDCA. Now, can you tell me whether as per the regulation or even the settlement rules, there is a concept of SLDAC? No. SDLAC? No. This is only a procedure. So if there is a procedure out there by which, just for example, there might be a thing that you have to take the report from the Lat Mandal. And if tomorrow you may come up and say that, look here, I've got the report from the Lat Mandal, so the proceedings have been initiated.
In this case, proceeding from initiated approval was forwarded, and there is an
Approval forwarded by whom?
by the district worship.
To
Resolution say if approval cannot be considered, page 23 year worship. The house approved the settlement proposal for the land center in one acre to Kalpana acre. So it was earlier approved.
yes, then
Then proceed. Section 5, page 27 regarding approval of general government function level of it says motion to refer to a public cited above and the honor to public clearly development promoted legally approved as the FNC meeting to be in favor of CSM government function level 1 to 2 percent. I will therefore request you to kindly consider and approve the above proposal. This letter for and to the principal secretary to the government of Nepal. In the year 2011, then election of the deputy commissioner.
no, madam, you have the 1991 policy, 2019 policy. Read it, clause 14.4.
For
14.4.
however, in view of the land policy and another government decision. Prior to adoption of this land policy, cases of interest landers person if found applicable and have been under continuous occupation of government lands or prior to 2001 may be considered for settlement of maximum of 1 5 acres of land in case of Guwahati and 1 10 acres of land in case of other towns and 1 time neighborhood homestead or thus if we apply for it irrespective of having land in rural areas subject to realization of the Guwahati is the rural district and
So as per this land policy of 2019 also, they had taken into consideration 1989 land policy and have come. So under such circumstances, there is no conformance of right unless it is done. It has to be on the basis of the present land policy. And that too you have to again apply.
what about my earlier application project? There was approved, considered then it
Tell me, any enforceable right is accrued on the basis of approval. Tell me.
on considered the matter, Lordship, that in the year 2019 and since then it's pending. They have not yet filed the application.
Fantastic.
On last occasion.
Madam, on the last occasion, I've asked you to get your information. Yes.
Yeah.
It's rural. Because you have said on the last occasion when the matter was taken up on 14/8/2023 to be rural area. They also have taken that stand that only 2 / 10 lakhs can be allotted. This is your rural area, not area. So this will happen as per the other one, no? 14, but not 14.
And they are occupying one with the Tata acres.
Yeah. As per 3. An indigenous family of a state who does not have homestead land in the name of any member of their family anywhere in the entire state may be allotted with suitable homestead land not exceeding half a bigha. The land so allotted shall be settled on periodic basis with the allottee provided the land is utilized for the purpose for which it is allotted within 3 years of allotment. Land thus settled shall be non-transferable for 15 years from the date of settlement. Shall ensure that a lender with whom the land is settled does not become landless again by transferring any part of demand. The land previously allotted under the rural house site may be expeditiously settled with the allottees or their legal as the case may be. The shall expedite the process of their for allotment of land to human persons under this policy. Detailed method and manner of the year will be issued separately. So you will come under 3.
Yes. Earlier than
Huh?
what is the year? Earlier than
No.
here pension within 3 years.
Within 3 years for what?
For allotment.
No. It would be allotted and you are to utilize within 3 years.
Years of
Because what happens when land is being allotted, then he may sell it off. And as such, there is another thing put out there, 15 years, no sale. So it has to be now done on the basis of that. Here, I don't think they will require to file a separate application, which is otherwise necessary for Guwahati, but for here, I don't think they need to file a separate application. Because you see, in Guwahati or in the rural, in town areas, it is specifically mentioned if they apply for it, which is not here. So here any application is there, he will be entitled to 10 lectures. Yes. Why? It is already there. It's already there. I make it X and make it.
In their website on the basis of earlier legislation. When their proposal is pending, then this land policy.
Challenge the land policy.
They will be covered under the earlier land policy or this.
Because the earlier land policy has already been repealed. That policy doesn't remain now. So this policy to allot is at the discretion of the authority of the state. Now the state has a different policy and the state does not save that. Because the land policy does not give you a right to get a land. No, it does not. It does not give you an enforceable right. But you are to be treated on the basis of that. Your rights spring from regulation as well as the settlement rules.
That regulation itself is has applied under legislation 5.
So you have a right to apply. There's no quarrel with that. But the fact that if you have applied, then the government may, why is this policy being made? The policy is not made unnecessarily. The policy is made so that there is no unevenness on the part of the government that I will give it to him or that. So they will have a policy by which, okay, we from here, this is the standard which we are maintaining. And that is why this land policy.
Submission whether should be considered under the earlier policy or the present policy because they have already applied.
No. Therefore, you have to show me that there is a right on the basis of an application. You show me now. I have already spent so much of time on this matter. This is the matter which was there because, Madam, on 14/8/2023, this was the specific argument which was faced by the government advocate. See the order. From a perusal of the materials on record, it transpired that the subdivisional land advisor Dhupri had in his meeting data recommended that a petitioner be settled with a plot of land measuring to the minutes of the. It transpired that subsequently observed that as per the then existing land policy, the permissible area was 1 bigha. In spite of that, no land was allotted for which the petitioner approached. It further appears from the submission of Mr. H. Sharma, the Learned Standing Council, on behalf of Vivad, that the land policy of 1980 has now been substituted by the land policy of 2019, whereby the maximum area of land that can be allotted is 2 katha 10 lesas. So this matter is there. Now, would this court not being interfered with the land policy, which is a policy decision of the government? If I say that no, those persons who have got, unless you say that on the basis of the approval, you have a right, or on the basis of an application, you have a right to get that land. Can you say that? No. Not possible. Now, today, when the matter has been listed, Ms. S. Murwa, appearing on behalf of the Deputy Commissioner, District Commissioner, Dhubri, has placed before this court an instruction issued by the Additional District Commissioner, Dhubri, dated 13/9/2023, wherein it has been categorically mentioned that in view of the land policy of 2019, the maximum quantum of land that can be allotted, settled for homestead purpose in rural areas is 2 katha 10 lechas. The said instruction is kept on record and marked with the letter X. Mrs. R. Chaudhary, the Learned Counsel, appearing on behalf of the petitioner, submits that the petitioner applied for land allotment at the time, settlement at the time, when the 1989 land policy of 1989 was in force. It was on account of the delay so caused by the respondent authorities, for which the land could not be allotted to the petitioner during the time when the land policy of 1989 was in force. It is a specific submission of the Learned Counsel for the petitioner that as the petitioner applied during the time when the land policy of 1989 was in force, and the recommendations so made by the SDLAC was also at the time when the land policy of 1989 was in force, the settlement of the land, if any, has to be made in terms with the land policy of 1989. This court had further, under such circumstances, this court had put a query upon the Learned Counsel for the petitioner as to whether a recommendation made by the SDLAC, or for that matter, filing an application during the time when the land policy of 1989 was in force, would confer a right upon the petitioner to be considered for allotment of settlement of land in terms with the land policy of 1989, though The land policy of 1989 had now been substituted by the land policy of 2019. This court had made this specific query on the basis that the right for settlement is not an absolute right, but would depend upon the consideration by the government on the basis of the existing policy. Mrs. R. Chaudhary, the learned counsel appearing on behalf of the petitioner, therefore sought for a short accommodation to address this court on this point. List the matter again on October 6th, 2023. At the top of the list for final disposal. Well,
Government has to file an affidavit.
obtain instruction. You have got the instructions? What is this matter about? Issue a rule directing to complete the proceedings initiated by the deputy commissioner.
Yeah, I thought, yeah,
and responded by the influence by law and the land for the housing accommodation to petitioner. Allotment under what? Housing accommodation, what is this? Under the national building,
I'm not prepared.
you are not prepared? On the last occasion, you were not appearing,
No,
And-
I have appeared.
it was given and none appears. Prior to that, you were appearing. On 25/8/2023, you appeared.
So yes, the file an affidavit, they will file.
There is no affidavit direction. There is only, I've asked for accommodation for 1 week to obtain instruction in terms with the order dated 24. What is the instruction? Yeah? Oh, you have prepared the affidavit. No, madam, I've read it, but tell me whether you are going to allot the land or not. That is not the answer. Here, the answer is as to whether you are going to settle the land of 3 acres in the favor of the petitioner who is in occupation. The land, the petitioner is in occupation of 3 acres. The total land of that particular dark number is 11 acres. Now, are you saying that the water resource department can put a signboard out there in respect to a land which has not been allotted? I'm asking you. Is it possible? Can't. So why he is mentioning that there is a signboard has any relevance? The signboard can't have relevance unless there is unless there is an allotment, isn't it? So where is the allotment? If there is no allotment, what type of affidavit is this? You file? Don't file. Come up with a better one. But I've asked you, you get it. The total is 11 bighas. On one side, you are saying that some police or some APR people are there. Very well, let them be there. But whether these people have been allotted, whether the water resource department is taking up, has been allotted, because every land has to be allotted by the revenue department, isn't it? So you have not filed it, don't file it. File a proper one. This code, by the orders dated 25/8/2023, as well as on 18/9/2023, directed the Deputy Commissioner Kamrup Metro to obtain instruction in the matter as regards the allotment of 3 bighas of land under the occupation of the petitioners. Are you in occupation? Okay, 3 bighas of land in respect of Dag number 3 bighas as regards the allotment of 3 bighas, 11, 3 bighas of land of Dag number 24 in favor of the petitioner association or society. Huh? I know. All these people are there. On behalf of the petitioners. On behalf of the petitioners. This is the same which is there in Annexure K. What else have you stated? You have not stated anything. The instructions which were placed by Mrs. S. Purva during the course of the hearing is not found adequate, in as much as the said instructions are instructions contain the information which is already there in Annexure K to the writ petition. Taking into account that the relief which have been sought for by in the instant petition is as regards the proposal to allot the land for housing accommodation of the petitioners. Mrs. Borua said, obtained the instructions on the next date, so fixed. List the matter again on 20/11/2023. Get your instruction properly.
14.
A das Uttadi. Senior House. Where is Mr. Bora? Bora, This is a small thing. This is as regards that the minister wanted to be a part of the 3-member committee. Now that has been stayed, and now it is presently occupied. So therefore, I asked him to get his information in that order.
He's on the legs, can it be taken out?
Okay, we'll take it up at 2.
I know.
Why? What is 15? No, 15. It is here. 14 is it? 14, yeah, we'll take it up at 2. Then 15. What is 15? Oh, there is one. Payment of 33 lakhs. Everything is done. We'll have it after vacation. Yes, you are there. APDCL.
Yes.
We'll have it after vacation.
Yeah, but otherwise, anyway, they were entering order in the people.
So that they are enjoying from 2021. You have not filed for vacating. They are happy with you are happy with they not paying you 33 lakhs. It is at the instance of this court, you have at last filed the affidavit on 28/8/2023.
Now at least.
Now, once you have filed the affidavit, now let us try our best to get that 33 lakhs from the petition. Is that the endeavor?
I prefer fixed it.
Chalo.
Yeah.
We'll take it for final disposal, provided this court takes up this bench. Anyway, list the matter, taking into account that the pleadings are complete, list the matter for final disposal on 9th of November 2023 at 2 p.m. Interim order passed earlier shall continue till then.
16 or 17. Yes.
16 and 17, there was some mention. He said that it will have to be taken up in the first half. If no affidavits are filed, you have not filed your affidavits. Mr. N.K. Debnath, the learned counsel appearing on behalf of the PNRD. Oh. PWD also did not file. So on the, you are filing it today. So, okay. No problem, but we'll ask the PN Commissioner and Secretary to the Government of Assam PWD to be personally present on the next stage. Because this court had already passed an order. The learned counsel appearing on behalf of the PNRD, Mr. N.K. Debnath had submitted that the affidavit which was directed to be filed by this court on 11/9/2023 would be filed during the course of the day today. However, neither the PWD is represented when the matter is called, nor the affidavit which was directed to be filed by this court by order dated 11/9/2023 have been filed by the PWD. The record reveals PWD is involved. Huh? No, PWD is not there, na? Hey, itu order of economic. আপনারে কাম PWD আসলে না না নিয়ে দিচ্ছি taking into account that the affidavit would be sorry this court by an order dated 11/9/2023 had directed the PNRD department as well as the BDO to file affidavits by 31/8/2023. Mr. N.K. Devnath, the learned counsel appearing on behalf of the PNRD department as well as the BDOs submits that the said affidavit could be filed during the course of the day. Under such circumstances, this court adjourns the matter to be listed again on 9th of October 2023. The registry shall bring on record the said affidavit. In the order dated, before concluding, this court finds it relevant to clarify that in the order dated 11/9/2023, there has been a typographical error whereby it was mentioned that there was a direction upon the PWD as well as the commissioner and secretary to the government of Assam PWD to file the affidavit. The said order, in the said order dated 11/9/2023, the word PWD appearing therein shall be read as PNRD. Yes,
I'm actually concerned with the extra of the body sheet, that's why. Request to appear.
oh,
One matter related to the long-term matter. And then the employee who have completed the project for the period, receiving a below overtime worker for 19,500 salary bonus for 180 days for they are held up on it, but they from the 3.56 years. They are supposed to find an activity, they have not found an activity.
they have not filed.
No.
Wait,
I have expected my.
what is your instruction?
Says by the key, this is all there, the total 140 petitioner by the. They have been represented by only one petitioner, petition number 1. And they have been represented without condition, all proper, genuine, authentic and supporting records, documents of all the total 140 numbers of it. And, so this is the.
You have not even cared to read the instruction before appearing before the court, or are you reading it for the first time? Yeah, tell me. That is a preliminary objection. Here is the claim of the petitioner. What is the claim? Do they have a claim? What is your stand?
Can we made by the petition number 1, one grab of everyone. Before. One today Sharma has finally taken care of all the work.
These are all payments for NREGA. How much?
180 days, they want.
But how can this court look into all these things?
They have engaged us, who are the below overtime person.
Then,
Or their experience and job cards that we have what? Now we are supposed to make the number. And I
when did you approach them? What are the materials you have placed before them?
So they have engaged us to completely, Pradhan Mantri Rozgar Yojana house for it. We have
So
given our labor.
how can we, this court pass any order in this matter unless you have stated anything out there?
But, we have approached the authorities, the final activity to the extent that we have our own, they are not engaged.
They're not saying that they are not engaged, but they are saying that the petition that we made, along with them are all the documents.
If you don't give it to them, okay,
But to our information, we have given one day, we will give money. It will not show answer to approach them and our claim may be settled within 1 month or 2 months. We will submit everything.
otherwise you won't.
The other, whatever we have got, we will give.
Whatever you have got means you have to show it to them that whatever may be, whether you are entitled or not.
Yes.
So, Mr. Devnath, the thing is, let them approach you and you take a call, verify if they are entitled, pay.
They've already made the petition, madam.
Whatever may be, let them, you make an inquiry 6 months. And then you take a call and pass, and if you find it, you pay them. Now, and whatever the payment of court fee, by 60 rupees for 100 and so many people,
Yesterday, already one of my cases.
yes.
But I was exactly I was thinking when I got the bid that I will be asked to pay. But
Yes.
considering their poverty, but below BPL. BPL side.
These are given to BPL,
They are the BPL workers,
but BPL is it exempted?
not exactly.
Then how do I exempt it?
There is a common, they also they are done it for all the workers. I am actually legal service man, nothing is there.
Okay, you be more generous, you pay from your own pocket. Mr. Biswas, you pay.
I
Do some,
definitely favor.
we are only asking you 60 rupees per person. Not much more than that. You pay it from your,
Can be considered whether.
because these are fiscal measures. How can you say that you are not going to pay? Fiscal measures has to be paid.
Accepted the picture.
Registry has accepted, okay, you want, we can ask them to recover from the registry persons. And if I do pass such an order, I can. The moment I pass an order, then none of the cases they will allow. You want to take that, we can. To recover from their wider registry, from that, from his salary or his pension.
We should come to settlement.
We do one thing, we issue notice to the Registrar General out here as to why this has happened. And to point out and make an inquiry and give it to us, so that we can put them to notice and then issue that it should be deducted from their salary. Better. This something has to be done in spite of so many orders have passed. They are not doing it every day and seeing it every time. If a petitioner normally approaches the court, he has to pay 60 rupees. If 180 petitioners have to approach normally, as per if you see the High Court rules, they are to apply. Actually, they are to file, every person has to file separate. But there is one exception being made, okay, if there is similar cause of action, one petition would do, but you will pay the court. Then why it is not being paid? I can only do so if you make a statement that it is, you are doing it pro bono.
Yes, exactly.
You are doing it
Just
pro
I will
bono.
update, just. If telephonic information, he seeks that.
I will mention that it has been done pro bono.
Yes.
Then in that case, I am going to do.
Yes, but definitely I am a promoter advocate also.
Huh?
I got channel, I am number one.
Pro bono.
Yes.
100 and how many petitions?
140.
140 petitioners have approached this court and have filed the instant writ petition, seeking a direction upon the respondent authorities for releasing their payment of their entitled unpaid wages of rupees 19,500 per petitioner for the period of 180 days of the scheme work done by them in the year 2017, as well as also for payment of compensation as per the provisions of the MGNREGA 2005. This court, prior to taking up the matter, had inquired with Mr. S. Biswas, the learned counsel who is representing the petitioner, as to whether the petitioners is not liable to pay the court fee, as their claim are individual and distinct from each other, as their entitlements are individual and distinct from each other. Mr. S. Biswas, the learned counsel appearing on behalf of the petitioners, submit that all the petitioners are below poverty line persons and he himself have done the instant writ petition, have taken up the instant writ petition, and they've taken up the cause of the petitioners pro bono in filing the instant writ petition. Taking into account the said statement that the petitioners are below poverty line persons and the counsel for the petitioner had also taken up the cause of the petitioner pro bono, this court would not insist on the payment of the court fee for each and every petitioner. Next. This court further finds it relevant to take note of that although the petitioners herein have made claims that they are entitled to an amount of rupees 19,500 per person, per petitioner, but from the materials of record, it does not transpire as to how the petitioner claims the said amounts. This court at this stage finds it relevant to take note of the submission of Mr. N.K. Devnath, the learned standing counsel for the PNRD, who submits that the PNRD department cannot make payment to the petitioner unless and until the petitioner places relevant materials before the PNRD department, before the concerned official of the PNRD department, showing their entitlement to the amount of rupees 19,500 per petition. Mr. S. Biswas, the learned counsel appearing on behalf of the petitioner, submits that he would advise the petitioners to submit before whom? Before the block development officer, programming officer, Senga Development Block, who is the respondent number 6, within 30 days from the date of the instant order. All the necessary documents showing that the petitioners are entitled to an amount of rupees 19,500 per petition. Mr. N.K. Devnath, the learned standing counsel, appearing on behalf of Mr. N.K. Devnath, the learned standing appearing on behalf of the PNRD department, submits that upon furnishing of such particulars, the respondent authorities in the PNRD department shall make necessary verifications, and if found that the petitioners are entitled to, shall make the due payment. Upon hearing, in view of the above, this court therefore disposes of the incident petition, giving the liberty to the petitioners to place the necessary materials before the respondent number 6. As regards the entitlement to the amount of rupees 19,500 per petitioner in the year 2017. This court further directs the PNRD department that upon such materials being furnished by the petitioners, the respondent number 6, the PNRD department through its officials shall make necessary verifications, and if it is found that the petitioners are entitled to the amount of rupees 19,500 or such other amount, the same be paid to the petitioners. This court specifically directs the Principal Secretary to the Government of Assam PNRD department, who is also the state coordinator of MREGA, to oversee that the said verification, to oversee the said verification process, and also take appropriate steps that the said verification be completed, that the entire exercise be completed within a period of 6 months from the date of submission of the claims by the petitioners. You have mentioned 2017. Is it because of pro bono you have forgotten 2016 to mention? You have said the year 2017. Yes.
Along with certified copy of the
Sure. Because everyone who cannot.
The registry, no, pro bono. The registry shall provide a copy of the order to Mr. N.K. Devnath, the standing counsel for the PNRD, to any of the petitioners herein may submit along with their claims the certified copy of the incident. হরিটো অফ করেছে না লাইভটো all your repetitions dismissed. All your repetitions are dismissed. Accordingly, this court, after this, directs as follows. The government officials who were responsible in facilitating such illegal appointments and the government officials who resorted to pay salaries to the petitioners without taking into consideration as to whether the petitioner's appointments had SLAC or SIO period are required to be made accountable as they have resorted to actions which have resulted in breaking the public trust reposed upon them. A constitutional duty is cast upon the state, therefore, to take action against such officials who have belied the trust of the government. This court therefore directs the Chief Secretary to the Government of Assam to initiate appropriate actions against such officials as per the extant laws, including civil and criminal actions. This direction is issued to the Chief Secretary, Government of Assam, taking into account that during the course of hearing, this court made a specific query upon the learned standing counsel appearing on behalf of the Health Department. As regards any criminal proceedings initiated against the then officials, for to which the learned standing counsel Health Department submitted that certain criminal proceedings have been initiated, but the same are not progressing as required due to the indifference of some departments. Therefore, this court, deeming it fit and proper, has issued the above directions to the Chief Secretary, Government of Assam. In view of the above analysis, this court has not interfered with the impugned orders of removal. Consequently, in view of the removal of the petitioners from the vacant sanction post, the government may take appropriate steps for fresh recruitment. It is the opinion of this court that if any fresh recruitment is initiated in respect to those posts, the petitioner would be at liberty to apply for such posts. This court directs the Health Department of the Government of Assam to relax and condone the age of the petitioners in the instant batch of writ petitions if they apply to the fresh recruitment process. Taking into account that the petitioners have already rendered their services for which the petitioners have received the salaries, the respondent Health Department shall not initiate any recovery proceedings for the petitioner in view of holding that the appointment of the petitioners were illegal and non-honest by this court. A copy of the instant judgment and order be sent to the Chief Secretary of the Government of Assam for due compliance. Thank you very much.
Timing at 14.
Yes, what is your instruction?
Notification is from the full plus 40 act.
No, that has been stated by this court, and now you are doing it. Therefore, the only question alive.
For the act, this is for the act. The notification will come in between.
No, as per the act would mean, because what has happened is you have issued a notification. Are you saying that the notification is contrary to the act? If it is contrary to the act, then only this court can say that it has to be according to the act. If it is not contrary to the act, this court has to adjudicate.
Executive order can override that particular act. It has single use has come in because of the in between the act. So the act is different, the process is from the pandemic, then the NOC will be given by the.
No, here is a case where there is a 3-member committee formed.
Yes, in the meantime, actually continue.
Now, as per that, is it required? This, we are concerned with Annexure 6, if I'm not wrong. High power committee, single window clear for getting clearance and planning permits and building permission consisting of the following members. Now, is it in consonance with the present laws? Huh?
I leave it for the-
No, what do you leave it to? Then I have to decide.
My lord, may I put it this way?
Yes.
This is absolutely, my lord, not, I mean, can. Who is this minister to give permission, my lord? Under the present system, my lord, the planning permit is being given by the Guwahati Metropolitan Development Authority and building permission is given by. My lord, that is the process going on. That was thought to be substituted by this. So this was state, therefore they are now going with the building permit and permission. But my lord, there are decisions of this personal to be considered an agreement. Government of Assam has taken steps to keep the entire DP to the GMC alone, not the municipal power. In fact, as far as my Assam Municipal Act is concerned, the act has been amended. Now, in respect of other places other than Guwahati, it is the only the municipal bodies who are involved, municipal or the urban local body. That is the larger risk. Now, if your lordship thinks that by interfering with this order, present system can continue and reserving the liberty has to raise the larger issue and another expedition, that is okay. Or lordship can decide this case, it is the larger issue which we are saying. The government of Assam has taken part in the decision in this regard matter.
Where?
Yes.
Huh?
Yes, please come to my lord. First, my lord will kindly come to page 8.
Yes.
Please come to para 7,
Page 8.
page of the report.
Oh.
That the petitioner begs to state,
Yes.
petitioner begs to state that pursuant to introduction of part Roman 9 capital A of the Constitution of India, thereby incorporating Article 243, Assam Municipal Act 1966 was amended, and the amended act is titled Assam Municipal Amendment Act. So, the petitioner begs to state that by Amendment Act of 2011 in the Municipal Act after section 53, the following new section 53A has been inserted. Transfer of functions from functionaries as provided under 12th Constitution. State government in appropriate department shall make arrangement for transfer of function from functionaries of municipalities as provided under 12th schedule of the Constitution. The arrangement mentioned above shall be of the following nature. The subject of urban planning, including town planning regulation of land use and construction of building, slum improvement, upgradation shall stand transferred to the respective. So, my lord, as far as other than Guwahati city is concerned, government of Assam has already done. Now, regarding Guwahati, my lord,
No, prior to that, if we see 53(1),
52, my lord,
53(1), 53A1,
yes. State government in appropriate department shall make arrangement for transfer of function, funds and functionaries to municipalities as provided under the 12th schedule of the Constitution. The arrangement mentioned above shall be of the following nature.
yes, shall make arrangement.
Yes, so Madam, the enabling provision has been made. That is, now as far as Guwahati is concerned, my lord, I just royal lordship attention to some document. So lordship will kindly come to page 24.
Yes.
Now, this is one of the minutes of the meeting held on 11/3/15.
Hmm.
Welcoming the members, the chairman requested Chief Executive Officer, Guwahati Metropolitan Development Authority, Commissioner, Guwahati Municipal Corporation to explain the provisions for use of planning permit under the Guwahati Building Construction Regulation bylaw. So, it's when for Chief Executive Officer explain the procedure for sanction of planning permit by GMC on recommendation of the town general. The application for planning permit shall be disposed of within a period of 30 days from the date of receipt of the application. Sri Sunil Commissioner GMC had informed that application of building permit shall be disposed of within a period of 45 days from the date of receipt of the planning permit. This implies that application for building construction permit shall be disposed of in a total 75 days in the Guwahati Municipal Corporation and the issue of planning permit and building permit as discussed thoroughly. After February discussion, the following decisions were taken by the chair. There will be one agency for building permission. The Guwahati Building Construction Bylaw 24/7 be amended. Chief Executive Officer DMDA and Commissioner will submit for amendment of the bylaw. Guwahati Development Department will present for amendment of the bylaw immediately on the 6th of Commissioner. So, then my lord will kindly come to the next page. The communication by the Commissioner to the Government Department. With reference to the above, I am forwarding here with due for amending of the Guwahati Building Construction Act of the 10th and Guwahati Building Construction Bylaw for declaring single authority for use of building permit. Now these proposals are there.
This authority should mean the Guwahati Municipal Corporation, as the
Yes.
case may be, within the jurisdiction
Yes.
of Finance.
Then my lord will kindly come to page 26. Amendment of Guwahati Building Construction Regulation Act. Authority should mean Guwahati Municipal Corporation. Then my lord will kindly come to the recommendation of the third Assam State Finance Commission. As per recommendation of the third Assam Finance State Commission, at recommendation number 32 and para number so and so, the commission endorses the view of the second Assam State Finance Commission and recommends that GMC alone should be allowed to exercise the power of granting building permission and written and the use of building permission both by GMC and GMC. Yes, my lord, will kindly come to page 27. This is the, my lord, recommendation of the task force. Report of this third State Finance Commission covering the period of 5 years from 1st of April 2006 to 31st of March 2011. Together with explanatory memorandum on the action taken on the recommendation of the commission is being laid on table of the House for Article 243 I4 and Article 243 Y2 of the Constitution of India. The summary of recommendation of the commission relating to devolution of
So, Mr. Chaudhary, your submission, as I could get it, is after the amendment which has happened,
Yes,
the power has been conferred upon the municipalities
hello.
alone. And as the power has been conferred, the municipalities have on their own exercised the power and thereby held that the GMC shall be the authority which shall give the building permission and building planning permit will be the GMDA. That is what has been done. Now, the government interfered by issuing the impugn order, by thereby saying that there will be a single window clearance and of which these are the persons were. So you are saying therefore that this order which has been passed is in violation to the constitutional amendment as well as also.
Present legal regime also. My lord, the proposed decision has not fructified. It was at that stage on. As long as today, my lord, planning permission is being issued by MDA, building permission is being issued by DIPS.
Now, what is the stand of the government?
My lord, of course, at that point of time, MDA had filed with the sorry.
No, GMDA is no business because
Guwahati Development Department,
where
paragraph 6
of
of their affidavit. They filed-
no one affidavit is filed by some town planner Guwahati MDA.
No, Umar Sharif, my lord,
Omar Sharif,
joint secretary PDC.
Arnab Sharma. Yes, Omar Sharif, yes. What does it say?
Yes, please come to paragraph 6 and 7.
Yes.
That with regard to the statement made in paragraph 9 of the resolution in the following makes to state that Guwahati Municipal Corporation Act has been amended in the year 94 by notification dated 6/5/94, where regulation of land use and construction of building and cross to the year section 8. The function of the building permission has been mostly relegated to Guwahati Municipal Corporation and other local bodies in now concerned as per the Guwahati Building and Construction Regulation 2010. Therefore, it is where reference has been made to Assam Municipal Act will not, also not be applicable as such. Any reliance made on the aforesaid act will not go to the extent case. That with regard to the statement made in para 10 of the petition, the opponent makes to state that considering the building permission aspect, the honorable party court in its order dated so passing civil rule number so had held that power of scrutinizing permission after coming into force of the master plan and zoning regulation and to carry out development work like with changes and such permission can be issued only on confirmation of the proposal contained in the master plan zoning regulation, but on no other ground. Further, as stated above, before granting any permission for erection, de-erection of a building, Commissioner James is bound to act. Proposal approved by GMDA with authorities limited to the extent of utilizing the construction would regulate the provisions of master plan. And if building plan satisfy the requirement, GMDA is bound to approve. Further, division bench of the Guwahati High Court is going for.
No, Mr. Chaudhary, kindly come to page 5 of that affidavit.
Yes, yes. Planning permit, yes. But they said this.
Therefore, the notification where they have, you really admit that it is the GMC who will be issuing the permission, GMDA will be doing the planning permit. And
why
then
this
they say at page 5,
Then why this particular?
then therefore notification of the act does not curtail the power and other bodies. Why is this single clearance notice? On one hand, the government is trying to have the ease of doing business. And this is the what you are trying to do. Would it be in violation of the ease to doing business, that act?
That I have not said, my lord.
Mr. Chaudhary, just have a look. Because that will, because that is also a statutory business act. So if it is, so
Well, their idea is instead of going from one office to another, help us into clearance regarding setting of justice. But these are all statutory functions. GMC Act is there, GMDA Act is there. How, my lord, when those authorities are named there, who will issue the permission? Who is the minister, my lord? Therefore, my lord, that Kane Commissioner's case comes into play, my lord. So, my lord, as far as the teaching order is concerned, there is no difficulty. But the larger point which we are trying to espouse, possible keep the issue open.
what is the larger point?
Another issue is Guwahati Municipal Corporation alone. But the constitutional amendment aspect has not even been looked into. Everything is based on the.
But you have only challenged that
No, of course.
notification.
Yes, we have also.
Then why should I go into the larger
No,
point?
must we keep them open since we have raised it. Now, you can say that other issues can, only this notification part, Lordship can say. We can make the rule absolute by saying, my lord, keeping the order in it. Yes,
Okay. We allow the petition set
Yes.
aside this.
yes. And that issue may be taken.
And dispose it. Yes. Oh, Mr. Sharma, what are you doing here? Huh? There is no election tribunal. Why the impugn result dated of the election of so and so should not be set aside and caused by issue of writ of certiorari, and why direction should not be issued to the respondents to mandatorily consider the election for Borough Territorial Council election with further use. You are appearing for Assam state election. You don't have an election the tribunal for the BTC.
There is a provision to notify, but we are not aware whether the government has notified us that.
No, it is not done under your aegis. It is done under whom?
BTC rules that,
No, who does the election for BTC?
but we do it.
Then you don't know.
Constitution of the tribunal is under the rules notified by the government.
you are saying that you are the person who will hold the elections. You are in charge, but you don't know as to whether an appellate authority is there or not. That is your case. So there is no tribunal.
It is to be notified under 778 of the Constitution. So whether this notification has been issued by the government or not.
It has not been done and you don't know from 2021. Yes. You are not in talking terms with the government. Or you are maintaining your independence. Then not to have talking terms with the government. No, something like that. Tell me, there has to be something. Otherwise, from 2021, you don't know whether it is notified. You may say, yes, 2021 onwards, till now, they have not notified.
That is.
That is means it has not been notified.
Not been
Tell me there that it has not been notified. Yes. So it is not notified. So this court has to decide under 226 where the records have been called for. Eh? Then, is there any bar before the civil courts to decide this? Because otherwise the Representation of People's Act holds it. Then whether there is a bar under the civil court to use. This court can't direct the authorities to, is it the mandate of the law that they have to notify? You are asking for you have made a prayer, you don't know. What? Huh? Where? Under what provision? You are paying for? We'll consider your question later on. First, for setting aside your election, we have to know where. And Mr. Dhar, you are appearing for
My lord,
the tribal,
that is the problem, my lord. This is record number 3, my lord.
which one? WPT.
WPT and BC. On 10 June 21. This, there was a creation of new department from this WPT BC. That is welfare of warden. So now.
There is another department.
And 3 departments came out, my lord, of that. WPT ever put in government. So that is my lord difficulty unless they are by the party and I don't represent them also. I don't, but I think from the court, madam.
Hmm?
They are golden, they are the model department.
There is another department
Another department.
and there is no standing council.
So government possibility, but my lord,
No, there is no government today.
anyway, my lord, I am also government council, I can, but
You are government?
I am government, I am the government.
Yes. So you can very well represent. Then tell me.
But my lord, there is no improvement on that
We
party.
improve. Now tell me.
Once
Yeah.
it is implemented,
It is only the question of handing over the file from one to another. You are appearing for the parent. Now we have to, you are now going to appear for the son or the daughter. Whether the son and the daughter is the prodigal son or the daughter, that is for you to decide. Now tell me.
my lord, once it is implemented, my lord, then only I can see an instruction from the new department, my lord. Because the last time I wrote a letter, that was the WPT, and by then that department was gone. So thereafter, my lord, that new department unless comes in, my lord, the party I.
Mr. Adhar, the learned additional senior government advocate submits that the welfare and plain tribe and backward classes department of the government of Assam was abolished, thereby bifurcating into 3 departments. That is, number 1,
Welcome, modern,
welfare of Bodoland department. Number 2,
tribal affairs, things department.
tribal affair plains department.
And my lord, that policy part went to.
Social and social justice and empowerment department.
Empowerment department.
Full-stop. The learned additional senior government advocate further says, submits that for the purpose of the instant case, it would be the Boroland
welfare of older people.
welfare of the Boroland department. Taking into account the above, the learned counsel appearing on behalf of the petitioner submits that he needs an accommodation to file an appropriate application for implementing the new department, the said department. 4 weeks' time is granted in that regard. And when is your term ending? Your term. You don't know. You don't know when your term is. You are not the person who is have been elected. You don't know when your term is ending. You don't know when your client was elected. You have not looked into the petition. So in 2021, for how long? 3 years, 5 years, 7 years? Huh? He was elected. And how much? What is the term? 5 years, 4 years, 6 years? 5 years. So you can have it after 2025. 22. এই নাম দেখাইছে না রেজিস্ট্রেট BTC. Let us see. 22. None appears on behalf of the BTC on call. In spite of the fact that the name have been duly reflected in the cause list. The instant petition has been filed by the petitioner seeking demarcation of the plot of land mentioned in Annexure C and D to the petition. It is the grievance of the petitioner that in spite of the application so filed on when did you file this application? No date. Where is the date?
21/11/2020.
21/11/2020. The respondent authorities in the BTC have not taken any steps in that regard. Taking into account the above, this court, taking into account the above grievance of the petitioner, and as the learned counsel for the BTC is not present in spite of a specific order passed on 11/9/2023 to apprise this court. This court therefore disposes of the instant petition with a direction to the, whom did you write?
My lord,
To the revenue,
Service Burma.
direction to the Deputy Commissioner Baska at Musalpur to look into the grievance of the petitioner as set out in his application dated 29/9/2020 and take steps accordingly. The same shall be done within a period of 3 months from the date a certified copy of the instant order is served upon the respondent number 2. 23. Yes, Mr. Mahajan. Mr. Mahajan, that day, after that, I passed that order. Have you seen it?
Yes, madam, I'm all right.
Order came up better than what I see it in the court.
Madam, I've seen it, madam,
I think now you will get whatever it is required. Anyways, tell me what is this? Proper investigation of an FIR lodged by the clear.
Now, my lord, that case possibly is over. Madam.
Yes, what happened?
Charge sheet was submitted, madam. When charge sheet was submitted, madam, different sections of the Indian Penal Code. There are about certain sections of the matter of prevention of atrocities of civil cust and civil crimes act. But in that act, other certain stipulations are there. That specific public hospital needs to be contained. Then the trial is to be considered 15 months, madam. Then there are some other on the day-to-day basis. That I did before the honorable court, madam. And that was recorded in the order. In all respect, madam. Several directions were given, possibly they may not have been, that order written 28/7. 28/7, madam. That is specified, madam. In all respect, madam.
This is which case? What is this case? Which case is this?
Compound district, madam, child, madam, child domestic.
Okay. Now, what has happened? In the charge sheet has already been done. What remains? The trial is proceeding.
The trial has to be proceeded in a particular manner, madam. It is specified in that order, dated 28/7.
Of this court.
28/7.
That was in 2021. What remains now?
21. Madam, that is, Lordship could kindly, madam, after the letter that has been quoted, on perusal of the aforesaid contents. Lordship kindly turn the.
Hmm. Yes. The charge sheet speaks that so and so of the scheduled class which stipulates trial of any offence to be carried out by a special court as stipulated under section 14 of the act, and in order to conduct the prosecution is required to be appointed. Yes, then
There is, madam, that trial is still going on, and that cannot happen, possibly, madam, because it has to be completed within 2 months.
it has to be completed.
Well, may I just read it?
Now, it has to be completed within 2 months.
2 months, and it has to be, the trial is to be conducted on a day-to-day basis. And special public prosecutor has to be there, and a special court has to be there.
But that is not a part of what you are asking in the petition.
But that is whether we subjected, whether
You may submit many things, but that is not a part of what is there.
that was giving investigation. with highly-
Yes, but then also this court can't keep this matter pending for unnecessarily. You have anything, you place it before the authorities or file a different petition if you want to do so, but this can't,
That is-
but this court cannot keep on taking up these type of matters.
Only thing, madam, is this order, that direction was given, my question.
No, this order, you see, the court may pass many orders. It is a different thing, but this court has to agree to that. In view of the speedy trial, Mr. Nath so and so, whether requires a apostle has to be looked. In addition, that an observation was made by this court referred to in so and so initiated by the year to curb the menace of side labor for which it was for the Iman. In order to get the instructions, Iman so and so. Now, in this case, what you are asking is, in this case, have you made those persons parties against who are they accused?
Oh, but can I read the prayer portion, madam?
Yes.
Can I be called respect, madam? Page 15, madam.
Hmm.
Page 15. Roman 4, madam.
Hmm.
With all respect, madam. The implementation of the provisions of civil custody.
Hmm.
Civil custody and civil crimes prevention of atrocities act 1989.
Hmm.
And appointment of a special public prosecutor of the section 15 of the civil custody and civil act prevention atrocities act 1989. Thereafter, my lord, leaving aside one, my lord, with all respect, my lord, protecting the victim's family and other victims, that is incorporated in section 15 of the act.
Hmm.
And thereafter, the transfer of the trial, my lord, that is decided.
Hmm.
That is the case status, my lord.
Hmm.
After framing of charge, it is given the evidence till 1.5 years over, my lord. That is not in accordance with the act.
But what you are saying is not a part of the record,
My lord.
is it? It is not about, you came at a stage when the investigation was going,
Exactly.
and now we are at a stage where the trial is going on.
Yeah.
Now, how can this court pass any orders to that effect of changing or giving a direction that it should be this or that, unless that is being brought? Or you challenge that you may ask or ask the authority, because if this court is exercising a rich jurisdiction, how can they do it?
The only thing, my lord, it is to be done in accordance with the only deadline, my lord. Then they will carry.
Tomorrow the manner in which you have made out the petition, tomorrow you may also, I'm a bit astonished. Why didn't you say that the appeal thereafter has to be filed before this court and then the Supreme Court can only take cognizance of this in this manner? That is the only thing which is left.
My lord, logic is correct.
Then
That will not-
at the stage of investigation, when you are asking for investigation, you are saying that the special prosecutor has to be appointed and in the hearing.
That's
Right.
what, my lord, is the-
How can you do so? That is, the cause of action has not arisen. You may ask, how can you ask that? If anything is there, you either have to bring it on record something that this has not happened.
One thing, my lord.
Because this court will be only presuming that this has happened.
My lord, one thing, my lord, not presuming. When charge sheet was submitted, my lord. Thereafter, I made this prayer, my lord, that was, my lord, with all respect, my lord.
Make the prayer on where?
That 18-7 order, my lord.
28/7, that is okay, understood. But the fact that what else has happened in the meantime, because the last time the matter came up was in 2021.
From thereafter, my lord, trial is still continuing. That is the. That cannot be done, my lord, as per the act itself. They cannot carry it out. We
So there, we have to strike down the trial.
No.
Then what do you want?
Only when the-
To finish it off soon. That's all.
2 months period, my lord, it is
But,
provided in the act.
but whether the trial is going on or not, how do I know?
The case status may have found out. It's still continuing. Okay, that is the issue.
But that is not a part of the year, no? We are part of the petition that the trial is going on beyond it, unless you bring it by way of an affidavit.
I cannot say, they say charge sheet has been submitted. So their charge sheet is under sections of the Prevention of Offences to Civil Customs and Crimes Act. Meaning thereby, the act itself within 2 months. With all respect, of course, it was there in the prior, our prayer portion, matter. Prior to it being charge sheeted during investigation, matter.
Let us see that.
Yes, yes. With all respect. Primarily, matter, with all respect. Under the section. Section 6, appeal, primarily appeal, subclause 2 and subclause 3, my lord. And thereafter section 50, and thereafter section 58.
Now, is there in a special court?
And they will be knowing, they may not have, that will be that, my lord, after all, it will get relief, my lord.
No, here it says, for the purpose of providing the state government shall, with the concurrence of the Chief Justice of the High Court by notification in the official gazette, establish an exclusive special court for one or more districts.
That is not, my lord, that is.
Provided that in districts where less number of cases under this act is recorded, the state government may, with the concurrence of the by notification, specify in so and so. It shall be the duty of the state government to establish adequate number of courts to ensure that that case under this act are disposed of within a period of 2 months, as far as possible.
Yes, sir. That is just take it. With all respect, my lord, that is why, my lord, when we take, my lord, this order was passed, my lord, and thereafter it has come.
Now, what is the offense? What is the offense under this act? Let us see. What is this offense?
Quantum of punishment is life, like, one section.
No, that may be there, but I am asking you, what is the offense? Section?
My lord, 3 to Roman 5. 3 to Roman 5.
Punishment. No, offense is what? 3, whoever not being a member of a scheduled caste or scheduled tribe,
Because the perpetrators are not, do not belong to the same caste.
whoever not being a member of scheduled caste or scheduled tribe gives fabricated so and so, gives fabricated evidence, commits thief, commits mischief by fire, commits mischief by fire, commits an offense under the Indian punishable with imprisonment of 10 years or more against a person or property, knowing that such person is a member of the scheduled caste of A, or such property belonging to such member shall be punishable with life. What is the offense? What has happened outside the charge sheet?
306,
What is the case?
commission of suicide. Abatement.
And commission of suicide, what is the effect? Second grade.
That is the IPC made of 10 years.
So commission of suicide, it will come under what?
306 of the Indian Penal Code.
That I know. I'm not on that. I'm only asking, commission of suicide, would it come under which provision? Would it be imprisonment for a term of 10 years or more? Commission of suicide?
Yes, yes.
No.
Abatement.
Abatement to suicide, 306.
Abatement is defined in 107, but the penal section is 306. P06 matter we call that effect matter is covered by P25 of the cell cup 1065. Depends on who it is. That act.
Would the term extend up to 10 years and 10 years and more would be the one and the same?
No, madam, different.
Then,
Now, my lord, this P06, so far as 167 is concerned, my lord, is 60-day period category. During it.
no, therefore, 306 says may extend to 10 years.
My lord.
Whereas 325 says 10 years or more.
Yes. Here it has been one of the intentional cases of my lord. 306 is specifically extended to 10 years. Here it has covered all offenses, not only 306, 325. Any offenses of the IPC, which, my lord, we call as impudence and punishment.
Omits any offense under the IPC punishable with imprisonment for a term of 10 years or more against a person or property.
Thereafter, my lord, then the quantum would be life. So far as the, my lord, this, my lord, ST Act is concerned. That is the tenor, without respect. Any IPC offense, my lord, without respect to follow in the ambit of 325, Roman 5 of the ST Act, my lord, without respect, my lord, the quantum of punishment has to be 10 years or more, my lord, to fall in there.
So therefore, the term 10 years or more, would it be same as extend to 10 years?
No,
So, but 306 only says up to extend to 10 years.
exactly, my lord. Here, my lord, without respect. Touching 10 years, my lord, that was the intention, my without respect. My lord. But it covers any offense of the IPC, which is 10 years or more.
So would it be the same?
Minimum is 10 years. It may touch 10 years. We have to go by that.
So therefore, you are saying that which may extend to 10 years and 10 years and more.
Different.
Would-
No, why may
If
not?
it is different, then obviously cannot 306 would not come within 3 to 5.
That is exactly my at the time of creating of charge there.
Ah.
Because police has incorporated 3 to 5. Why may not I am saying, my God? Touching 10 years, with all respect, my God. That's whatever is there in the statute, not my love, laws of my apex court and high court. I'm not saying that. The statute contains that it can touch 10 years. So the 306 is concerned, with all respect as student of law. And 325 of the Civitas Act, sorry, Prevention of Atrocities of Civitas and Civitas Act, it talks about offenses which includes offenses where after conviction, where one can be convicted
For
a
10 years or
period of
more,
10 years.
or more.
That is because of 306 fall within that. Or any offense of the IPC, which should be, if convicted, would be more than 10 lives. If in that.
And I understand, therefore I am putting you the specific question, whether the term extend to 10 years would include 10 years or more. It would. That is your submission.
Yes.
And you are saying no. It would include 10 years because they may extend till 10 years means the upper limit is 10 years here, but here the lower limit is 10 years. It's 3 to 5. So 10 years is already there.
Yes, yes. So I follow in the category.
That is what you are
I
saying.
follow.
Yeah, you are saying no. That is
No,
why.
I put it otherwise, madam.
But I can't help you unless you bring it on record something or ask some further detail of or file a miscase. Then only this court can further proceed.
Can it be like this? Because that report was because of that within.
Mr. Mahajan, kindly
Yeah, I do.
explain.
I do.
Unless and until you bring on record something that this is not being done, how can this court pass any further order? How can this court now know that it has gone
Because it is
more than 2 years? Then only once you give that, I can pass the direction, directing them to have it within these 2 months and finish it off.
Fine.
Although more than 2 years have already passed, but then also court can very well direct in view of this to do it. But unless you don't do it, I
Can
can't.
it come up after a week? I do that.
Yes, Mr. B.K. Mahajan, the learned counsel appearing on behalf of the petitioner submits that he would like to file an application seeking additional directions, taking into account that there has been a delay in disposal of the state trial, although it is the mandate of the Scheduled Caste and Scheduled Tribe Prevention of Atrocities Act 1989 that such trial needs to be concluded within a period of 2 months as far as possible. Accordingly, he is given the liberty to file such application. To list the matter again on how much time? Can I have it on 11th?
Minor.
List the matter on 11th of October 2023, provided such application is filed by the petitioner.
Any of them?
24.
Yes,
I am the owner of a 6 acres of land covered by tax number 52 of Article number 1.3 of village Gorpara under Muja Hokumai. On Act 2021, the purpose of the restaurant number 4, Armana house, standing over my house, intending to demolish it for extension of the road, Coco Boyam Road. The house has consisted of 6 numbers of pillar, my lord. Out of that, they wants to demolish 3 numbers of the.
no, why will they demolish unless they acquire?
Yes, my lord. They have neither required no notice of acquisition.
Then there is no apprehension. There is no notice of acquisition. How can they do it? I make it clear.
My lord,
Matter ends. You see, they cannot take your land.
yes, my lord.
They cannot demolish your building unless they do so in accordance with law. So as of now, there has been nothing issued. So nothing remains. So if they do so, they have to give you notice. Matter ends.
My lord, my lord, except my land, my lord, and I get some protection from the street, my lord. Others, land.
No, Mr. Das, kindly appreciate one thing.
Yes,
The
my lord.
question whether any acquisition, whether it is in public interest or not, is a question to be decided by those authorities. This court can't decide this. Let them show that it is in public interest.
Slider require no notice of the.
Absolutely. So without acquiring your land, nothing can be done. Yes, madam, any instructions? So therefore, you cannot do anything on his land without following the due process. The petitioner herein has filed the instant writ petition on an apprehension have filed the instant writ petition, being alarmed at the earmarking of his RCC building, which consists of the ground and the first floor, by the respondent authorities, and thereby proposing to demolish his RCC building for expansion of the road. It is the case of the petitioners that neither any acquisition notice or any proceedings have been initiated insofar as the land and the house belonging to the petitioner. Pursuant to the filing of the instant writ petition, it reveals that this court, by an order dated 23/6/2021, directed the respondent number 3 and 4 not to demolish any part of the residential house of the petitioner falling within the Patta land. However, it was, however, made clear that in the event the authorities find encroachment by the petitioner, then also appropriate notice with reasonable time may be allowed under law before taking any action to demolish the building of the petitioner. I've heard the learned counsels for the parties. Ms. Yudas, the learned additional senior government advocate, submits that pursuant to the interim order passed by this court, there has been no steps taken to dispossess the petitioner from his land or to demolish the building of the petitioner. So, taking into account the above, this court is of the opinion it is the opinion of this court that if the petitioner is the owner of the land and as well as the building standing thereon, and is the owner of the land, whereupon the building stands, the respondent authorities cannot dispossess the petitioner from his land or demolish the building of the petitioner standing upon his land. The respondent authorities can only do so by following the due process, else it would be an infraction to the rights under Article 300A of the Constitution. It is further relevant to take note of that the respondents herein have not filed their affidavit even after a passage of 2 years. And as such, the stand of the respondent authorities could not be known as to why the building of the petitioner was earmarked for demolition. Be that as it may, this court therefore disposes of the incident petition, thereby directing the respondent authorities not to dispossess the petitioner from his own land, as well as also from demolishing the RCC building standing upon his own land. Without following the due process.
The building is not residential, it is commercial. It is top of the order. And the
Have I mentioned in residential? It must have been written here residential somewhere. I have never mentioned that. Why will I mention? How will I know?
I am running from.
Here, the court also passed, I never, no, the court said, from demolishing any part of his residential building. I never said that. Earlier order has been passed. Yeah. No, that is that interim order. I never said. My order never says about what type of building.
Otherwise, the frame we have completed except the portion in front of
No, his house means you want to acquire.
our alignment is not the government land, part of the building.
Why you have not filed any affidavit?
On this, if the authority has an exercise of it is a part of the government, a part of the road process. Then let them go ahead. We are not.
It is however made clear, clarified, it is however clarified that if the building of the petitioner is standing upon government land and is encroaching and thereby affecting, encroaching upon, is standing over a government land, then the above directions which have been passed, then in that case, the respondent authorities would be at liberty to take such action as per the provisions below. No, anyways, Mr. Nayak, I have made it very clear. Standing upon his own land, because when I was dictating, I made it very clear. RCC building standing on his own land. I never said that in the land, on his own land. So not to dispossess from his own land, as well as not to demolish of the RCC building standing on his own land. If it is outside, it is.
This is the last time.
You think whatever me. Yes, who is appearing here? Huh? Ah.
Thereafter, another batch will be filed challenging settlement order, and there is that order. And most part, this matter also remains to talk.
Why?
Because 7/6/21 sale notice, a bigger statement. He has been given a hold on, he has been given a lawyer, but he was the required for the court challenging the settlement order. There is stay order.
And what is he challenging?
He challenging the sale of the dated 7/6/21.
Why?
Because he's saying that he was not able to run the Mohammed lordship. His first period is over,
Oh, his extension.
extension. So there's
And who is running now?
this one is lying at the lordship. Because there was a stay order.
Where is that other matter?
I have the order of the yeah.
Let me take up that. I will do one thing. List this matter with that and pass that order. That day I passed. You were there, na? Sale of the house.
I'll get the order.
Then only, once you get hold of the petitioner council in that manner, only then things improve. Yes.
Same all over.
Because the state, something has to be done. Either it has to be disposed of, you can't keep on, because if it is not operational, then the state is losing.
Yes, sir.
Are you not losing?
We are losing.
Or you have too much money?
No.
Then,
Like this, madam, thank you.
I think better off, huh?
Yes, sir.
Better off if it comes to me only. Now mining plan has been submitted.
Mining plan has some allotment, but this is an allotment order for state allotment.
None appears on behalf of the petitioner on cause. Mr. R.R. Gogoi, appearing on behalf of the Forest Department, submits that the instant writ petition is connected with WPC number 1466/2023, as well as WPC number 1737/2023, wherein the sale notice which have been put to challenge herein, there has been certain orders, wherein pursuant to the sale notice, the sale notice which have been challenged herein, the responding authorities have already given the letter of award, letter of settlement.
Allotment not.
What
Because
is-
there was a state.
No, no,
Not allotment.
you have not given anything.
The prior respondent who has later been selected, he has been not nation to obtain a mining plan.
No, mining, prior to mining plan, you give him something. Then only you ask that kindly provide your mining plan.
Yes, sir.
What do you do? Initial letter of acceptance,
Letter of intent.
wherein a letter of intent have been issued to one of the bidders. And thereupon, the said letter of intent have been challenged in the said two writ petitions. Taking into account the above, the instant writ petition be listed. Taking into account the above, the writ petitions being WPC number 1466/2023 and WPC number 1737/2023 be listed before this listed before the court, along with the instant writ petition on, when do you want? In notice issued any time given? No time.
No time pass.
Okay, we bring it now, very soon. Only things we move. Be listed on 11th of October 2023.
Available.
There we will take care.
Available.
Yes. What do you want? Excise warehouse. Petitioner is a licensee of the bonded warehouse in the name of so and so. After amendment of your procedure adopted is the warehouse will now not be known as so and so, so and so, so and so. In the interim, and case made out an Iman is directed for the action. And what is this notice? Yes. You're not interested with the money? The excise must be so rich. There must be very prosperous business of excise, I suppose, huh?
Lordship, some time may be granted,
For what?
instruction
You should allow the petition, as we have not filed the petition. Huh? What is there? Your counsel on the last occasion said in the year 2021, Mr. KP Pathak submits that there is a possibility that in respect of some of the liquor, the excise duty may not have been paid when it went out of the warehouse. If that is so, the respondents may work it out and inform the petitioner. The petitioner shall cooperate in that respect. What remains? Excise must be doing prosperous business, and you don't need the money. How much is the money?
Around 8 crores.
Huh?
About 8 crores.
So, 8 crores must be peanuts for you. It's peanuts. That is why you are not bothered to file an affidavit. There's no stay.
There's an order for the last order.
Where? Prima facie, yeah, that like the further action under RIA against RIA shall not be taken. Means, so you are not, we make it absolute. In time order, make it absolute. Huh? Till his license subsists. What do you say?
Last of it.
What last opportunity? 2021, you have not filed the affidavit. This is the state of affairs. When there is a stay order operating. This is not done. The instant writ petition has been filed by the petitioner, challenging the notice dated 3rd of March 2021, whereby the petitioner was directed to deposit an amount of rupees 3,42,53,221.22 paisa, being the ad valorem excise duty, and rupees 2,65,014 being the VAT, in 2 installments, that is 50% on or before 31st of March 2021, and the remaining 50% before 30th of April 2021. It appears that the petitioner thereupon have challenged the said notice before this court by filing a writ petition on 7/5/2021. On 14/7/2021, this court passed an interim order directing the respondent authorities not to take any action on the basis of the notice dated, demand notice dated 3/3/2021 against the petitioner. More than 2 years have passed by, but the respondent authorities have neither filed the affidavit nor have produced any instructions in that regard. It appears that the respondent authorities, more particularly the Excise Department of the Government of Assam, is not interested in the recovery of the demand as made in the impugned notice dated 3/3/2021. Be that as it may, This court fixes this matter again on 13th of October 2023, thereby giving a final chance to the Excise Department to file the affidavit by 11th of October, file the affidavit or obtain instructions by 11th of October 2023. So it is made clear that if the affidavit and or instructions are not obtained, the affidavit be filed by 11th. Affidavit no instruction. Affidavit be filed by 11th. It is made clear that if the affidavit is not filed by the said date fixed, it shall be presumed that the respondent Excise Department shall have no objection in setting aside the impugned demand notice dated 3/3/2021. A copy of the instant order be served upon you. What's your name? So and so. The learned counsel. You have excise. You are the standing counsel. Okay. Now, then we put it non-appears for the stand. A copy of the instant order be sent to the principal secretary to the none appears on behalf of the Excise Department on calls. A copy of the instant order be sent to the principal secretary to the Government of Assam Excise Department for necessary action. Well, none appears. Oh, same type. Same order. What is that order? Hey, same. Yeah, whole amount to be. Oh, your affidavit is filed? No. No affidavit. Nothing. Yes. He was here and he left for that. Don't make this type of submission. Amount is different. They are not interested. You know what order has been passed, you know. It seems that the Excise Department is not yet. Here the amount is 7 crores 16 lakhs 48,228.50 paisa. It is at Belaram excise duty and VAT whole 4 crores 47 lakhs 04,260.04 paisa. VAT. It will put like in time order passed earlier shall continue till then. Yes, who is appearing? No, 9 appears. Yes, Mr. Bulwa, what is it? What is he asking for?
My lord, the electoral inspector's report is on record.
What does he say?
My lord, it attributes the incident to the negligence of the victim, my lord.
Oh, is it?
Yes, my lord. And therefore, perhaps now they have a statutory remedy of preparing an appeal, that section 126 clause 2, my lord, to the appropriate government.
আজি মই ৰাতিপুৱা এটা 8 নম্বৰ কিমান আছিল that was the matter of Mr. A.R. Bhuiyan. এই 8 নম্বৰ আইটেমটোৰ লগত এটো দি ডিসপোজ petitioner 9
My lord, in the last 2 occasions, the petitioner sought time to find reply for affidavit to the electoral inspector's report.
we do one thing.
Without, my lord.
Now we do one thing. Let us have it on some other day. Next week. Making it clear if the petitioner is not there, we'll dismiss for default. None appears on behalf of the petitioner on call. It is also seen that on 1/12/2021, as well as on 26/8/2022, the council appearing on behalf of the petitioner had sought for time for the purpose of filing their affidavit in reply, which have also not been filed. Accordingly, list this matter again on 13th of October 2023. It is made clear if the petitioner is not represented on the said date, the instant petition shall be dismissed for non-prosecution. Your name you A Burwa for SC petition. Yes, what is this? What?
All these purposes and transmission passing for court of and below. And protection of the compensation.
Transmission has, the compensation has been adjudicated upon
Yes.
and you have not been paid.
I have been, we have prepared the check and accordingly we have deposited the check with the circle officer, but they accused the petitioner, they have received some complaint. That's why again the check has been returned back to the.
Why?
Some complaint is there, that is only circle officer can. Change.
You do one thing, you got the check back? You got the check? Fantastic. You have the check. Deposit it with the register. He will collect on proper identification matter and what else?
Some complaint is there.
Complaint is what?
That is, only circle officer can.
So you don't know what is the complaint, whether he is not entitled to the amount.
The circle officer is returned back.
And the circle officer, you never know what these people do. The amount is 3,65,000 he is entitled to. Now, we will say, as per your award, where is the award?
Yes.
Hmm?
About the period, this is 5,500.
Where is the award? Ah, Ali Akbar. Ali Akbar is entitled to how much money?
65,465.
Huh?
Check is there. I will respond address case number 90.
Now, is there any, is there, just wait, who has written this? With regard to the subject above, I would like to return the 3 numbers of checks. Public complaint. What is this public complaint for? Huh? Who are the petitioners here? Let us see. Only Ali Akbar.
Yes.
What is the public complaint?
They are getting remembered.
Huh?
As per my.
And who is this person? Respondent number 6?
Assam Electricity Corporation.
This is the Deputy Commissioner Bongaigaon has filed an affidavit. Other petitioner and his son has no possession of the remand and as per village. It is stated that village so and so are both one and the same village as so and so. Oh, here there is serious allegations. against the petitioner? Huh? Petitioner has also filed reply. So no, and then this thing is, how can this be adjudicated here now? We will hear it after vacations. The reason why I'm saying it here, whether the deputy commissioners can have a say after the fixation of compensation by them in your favor, or an award being passed in your favor by the deputy commissioner, that this is there, that is there. Because what is the reason why the circular officer returned is public complaint, whereas the deputy commissioner says something else. Deputy commissioner alleges that you are a person who is taking money from everybody.
They are well, this kind of election fraud.
So taking into account that the pleadings are complete in this instant matter. And also the fact that the AEZCL had sent the check of the amount claimed by the petitioner to the circle officer, which was returned by the circle officer concerned. This court would take up the matter for final disposal on 9th of November 2023. List according. Okay, on 23rd of November 2023.
You are.
Who has to file additional affidavit? Yes, you filed. For why? Whether any amount is due from the department to the petition. Shall obtain instruction. There is nothing. What means? Huh? You will go. Where I should when I raised the respondent, when has been filed in this connection, there is no other pending liability in respect to the contractor so and so to be paid by the deponent animal. Further, the petitioner have not executed any work in Sutia so and so, and as such, there is no outstanding. So nothing means. You can't by way of an additional affidavit, am I not going to hear? Nothing. What you want to file? You are asking not small money. Or 12,40,179. Now, the instant petition has been filed by the petitioner, claiming an amount of rupees 12,40,179, which is due to the petitioner, which the petitioner claims to be due to him or her, him, on account of certain works being done by the petitioner. In connection with done by the on account of certain works being done by the petitioner. When the instant matter came up for consideration on 11/8/2023, the Learned Counsel appearing on behalf of the Irrigation Department, Mr. N. Upadhyay, submitted that as per his instruction, the petitioner is not entitled to any amount. Be that as it may, this court directed the irrigation, directed that the Irrigation Department files an affidavit bringing on record that stand. Accordingly, an affidavit was filed by the respondent number 4, that is the executive engineer, Sutia Division Irrigation, wherein it was categorically mentioned that there is no other pending liability in respect of the petitioner to be paid by the Sutia Division of the irrigation department. It was further mentioned that the petitioner had not executed any other work in Sutia Division irrigation. And as such, there is no any outstanding liability against the petitioner from the Sutia Division of the irrigation department. Taking into account the specific stand, wherein there is a complete denial to the claim made by the petitioner, this court is not in a position to adjudicate the said aspect, taking into account that that would be a disputed as it arise, as it would entail entering into the arena of disputed questions of facts. Considering the above, the instant petition therefore stands dismissed. Stands dismissed. On the ground of maintainability. The dismissal of the petition, however, shall not preclude the petitioner to approach the appropriate forum if so advised. And the period from 26/8/2021 till date be excluded while computing the period of limitation.
Supplementary set of 7.
Hmm. Hmm. Respondents have not filed their affidavit by Iman. They have not filed their affidavit. Yes.
This matter, as far as this fight about it.
Mr. Gogoi, why are you fighting with these small things?
He's running the point shut about it.
Understood. Why you are fighting on these small things? You want to give it to the private respondent. You are private. Give it to her another shop. Give him one shop. If you can waive off amounts of in crores in the other matters, why can't you do this? What is the small thing?
Private respondents are complaining about it.
Huh?
The private respondents are complaining about it.
Yes.
And they are complaining about the opening of the shop of the petitioner. The petitioner is supposed to saying that you have to. So that's a
You, without show cause notice, you
Yes.
close down the shop.
Yes, of course. So we have proposed the board and product the order is running it from without taking about it.
Okay, give us show cause. We set aside that order. Give him a show cause.
The private respondent, if there's any complaint still regarding.
They have complained to you. On the basis of that, give him a show cause and do it whatever you like. Isn't it? Nothing. And not to do anything till that. That is. Huh. Madam, you are appearing on what basis? No, are they party? Oh, all these people are parties. By an order dated 13/3/2019. The council. Okay, let me write it down. The instant petition has been filed by the petitioner challenging the order dated. Where? Huh? Challenging the order dated 9/4/2018, issued by the Deputy Commissioner Golaghat, Excise Branch, whereby the petitioner was directed to close his shop immediately and shift his licensed premises from the existing site to another suitable site. It is the case of the petitioner that the said impugned order dated 9/4/2018 was passed on the basis of some public complaint and some inquiry report of the circle officer, Golaghat Revenue Circle, without affording an opportunity to the petitioner. And as such, the impugned order dated 9/4/2018 is in violation to the principles of natural justice and accordingly in violation to Article 14 of the Constitution. Your name, so and so, appearing on behalf of the private respondent, submits that the petitioner herein is operating in violation to the provisions of Section 290, Rule 290, 90 or 95.
295.
Rule 295 of the Assam Excise Rules,
Assam Excise Rules.
2016, in as much as they are operating within a residential
Yes, it's a responsibility.
area. Mr. R.R. Gogoi, the learned counsel appearing on, standing counsel appearing on behalf of the Excise Department, submits that taking into account the said stand of the petitioner, he would not like to oppose the instant petition. He, however, submits that the Excise Department be given the liberty to take appropriate actions by putting the petitioner into notice. Taking into account the above stance of the parties, and more particularly, as the impugned order dated 9/4/2018 was issued in violation to the principles of natural justice, the said order is set aside and quashed. Next. This court further makes it clear that the setting aside of the order dated 9/4/2018 shall not preclude the respondent Excise Department to take steps on the basis of the public complaint by giving due notice to the petitioner. None appears. Why have you not filed your affidavit?
Last translation, you file it. It's not-
No, we will consider you have no objection. No objection to that amount. This is a very serious thing. And what is wrong? Till this court does not act on all of you, KP Pathak and others, till this court does not act and put you to notice, nothing happens to all of you. All of you have belonged to the same one. Everybody has the same thing. And as such, because sometimes KP Pathak appears for forest, for electricity, as well as also for, regarding this one, forest, excise. No, you don't do. Till I put you to notice that this is going to happen, then only you wake up. Today in the morning, there was one matter of Mr. K. Chaudhary. The electricity department was sleeping, APDC. Then I say that you don't want 33 lakhs. Then they file an affidavit. And today say that no, 33 lakhs is the question, so kindly take it up. Right? Because of me, you are filing and you keep quiet, you don't do anything, and now you are saying all these things. Make sure, all of you, you, A. Borua, KP Pathak, everybody, belonging to the same branch. Be careful next time. নাম তো ঘুরাই দিব আর গগৈ নো রিপ্রেজেন্টেশন ইন দিস ইজ বুঝাই দিবে আর গগৈ দি আর এখন পুঠিয়াব নালাগে প্রিন্সিপাল সেক্রেটারি লেখন পুঠিয়াব নেক্সট টাইম আই এম পুটিং ইট
71.
কিন্তু
Regarding reservation of post for the post of president in Nalbari Jilla Parishad.
post of
Post of president.
oh
On rotational basis.
I have asked for something. It is made clear if the affidavits are not filed by so and so by the Assam election as well as this quarter. No affidavits filed. When?
Yes, sir.
I'm not got it. Come on record. Yes. Oh, who is respond number 2?
Election commission.
Election Commission.
But this NRD department, they are the main respondent, they have not filed.
Huh?
NRD department, for certain reason, they have not filed.
Oh, yes. Why? Hello? We asked the Commissioner and Secretary to the Government of Assam PNRD Department to be appear. To appear next stage. Because here is a very important issue as regards the women's reservation. And not only that, there was a specific direction passed by this court earlier, directing you to file your affidavit to ADA, not me. The order was passed on 26/7/2023. 2 weeks' time was granted. And there was also mentioned clearly that this is an important issue. They have filed, you have not filed. So we call the Commissioner and Secretary, there is no way out. Okay, we call the Commissioner as well as the Secretary. No, we'll make it Commissioner as well as the Secretary, both. No, it is not. Because nothing happens. PNRD department is another department. PNRD, PHE department are great departments. They will do whatever they are. This is the mandate of the Constitution. Why you are not doing it?
That's why I tell the commission, commissioner's office, letter, the secretary's office.
Mr. Ardube, appearing on behalf of the Assam State Election Commission, submits that an affidavit have been filed on behalf of the Assam State Election Commission pursuant to the order dated 13/9/2023. On the other hand, Mr. N.K. Devnath, the learned counsel appearing on behalf of the PNRD department, submits that neither he has been given any instructions nor any affidavit has been filed. On the last occasion, that is on 13/9, at this court, taking into account the conduct of the PNRD department officials, of the Secretary, Commissioner, PNRD department, as well as the Secretary of the PNRD department, finds it relevant to take note of, to reiterate that in the order dated 26/7/2023, this court, taking into account the important issue which is involved, had directed the PNRD department to file their affidavit within 2 weeks. Even after 2 months, they did not file their affidavit. And as such, on 13/9/2023, this court directed the PNRD department to file their affidavit. Else, it was observed that appropriate directions shall be passed for personal appearance of the Commissioner and Secretary to the Government of Assam PNRD Department on such date as may be fixed by this court. Taking into account the above, list the matter on five o'clock. 5 o'clock today. Take it up at 5 o'clock. Call the PNRD Department Commission. I think that 5 o'clock. No, 5 o'clock today. This is not. I'm here till 5 o'clock. Because this amounts to a violation of this law. This is being done with impunity. List this matter, directs the commission, the secretary to the Government of Assam PNRD Department to appear in person at 10:15 a.m. on 3/10/2023. No, it can't be on 5th. It has to be on or today at 5 o'clock. Both of you, choose it out. I'm giving you 5 minutes. You call at 15 minutes here. No. We'll have it at, ask him to be in video conference. We'll take it about this. Why? Ask him to come on video conference. Amar etuk mati your computer. Give him the link. I'll ask him the same. Because he also need not come, let me tell him why he has not come. No, video conference, we can ask him. It will do it. No. Itu amar computer material, video conferencing or link to it. Whoever it is, who is more responsible than each other.
Number 32 and 33 for us.
Yes, who is appearing? Taking into account the office notes, the service upon the respondent number 2 and 3 being not complete, the petitioner is directed to take fresh steps upon the respondents within a period of 1 week from today. List according.
and 35.
Who is appearing for respondent number 4? What is this contempt? These are so old contempts. What is there? Huh? Now you are asking which order? For violation of which order? In the interim, since the reference educator course is scheduled to commence on so and so, the Assam Football Association is directed to immediately forward the petitioner's application to the Assam Football area for necessary action. What remains now? What happened to the petition? Where? Is it there? Shalom. What right do you have? Let us dismiss the petition, then the matter ends. Where is it? What is your case? Let me see. What is your case in your petition? Should not be issued declaring the decision and consequent action of the private respondent in not forwarding the petitioner's application dated so and so as unfair so and so. Like nature should not be had to recall or withdraw or cancel the impugned decision in so and forward the application of the Now, in view of this, you are challenging an order of not forwarding an application dated 25/3/2014. For what? Huh? Now, is anything alive now in the repetition? Then what remains?
What is that? This one is the good part order. This one is the good.
You are asking for cause of action from this court's order. Now nothing can be done in this petition. Take, I've heard the learned counsel for the parties. The instant writ petition has been filed by the petitioner, seeking for various directions that seeking that the order, the decision, seeking for quashing of the decision of the respondent number 5 not to forward the petitioner's application dated 25/3/2014 as unfair, illegal, injudicious, arbitrary, and discriminatory, as well as also seeking a direction that the application of the petitioner dated 25/3/2014 be forwarded to All India Football Federation AIFF and to allow the petitioner to attend the course scheduled to be held with effect from 5/6/2014 to 7/6/2014. This court, upon duly perusing the materials on record, from a perusal of the writ petition, it is seen that nothing survives, taking into account that the order the decision which was sought to be quashed was in respect of not sending the application of the petitioner to the All India Football Federation for allowing the petitioner to attend the course to be held with effect from 5/6/2014 to 7/6/2014. As the same period have already lapsed a decade ago, nothing survives to be adjudicated now in the instant writ petition. And as such, the issuance of a writ also does not arise in the present facts. Consequently, the instant writ petition stands dismissed as stands closed as it has become infructuous. Now, contempt, tell me, what is there? Huh? Good. Since the referee educator course is held on demand, he is directed to immediately forward the petitioner's application to the Assam for necessary action. Then, who has this order was passed 28/5/2014. Okay, and when did you forward it? On 29/5/2014. How did you send it?
This I have submitted before the Honorable Secretary of Assam Football Federation matter. Initially, he refused to accept, then they have filed on miscase matter. That order is at page 15.
Page 15. Yes.
This was passed an instant order dated on
ensure that the report and recommendation reaches the swine so in due time. Okay, then,
Then my lord, document has been completed 17.
Hmm.
On 5/6/2014. The decision reported, and document and bottom 5 matter 5/6/2014.
hmm,
Voted on 5/2/2014 and same as better. When returned by as we have received no document from Assam Control. No document is received.
hmm,
They have submitted, they have sent one letter.
hmm. So they have only forwarded. They were only forwarded, but there was a request that they should not be allowed to for you to participate. Yes, then,
They have made the remark.
ah,
But this, there is a order from the Honorable Court to send this application along with all the documents so that it will reach in time.
ah,
Now, the first order was passed on 28/5. Then this second order was passed on 2/6, madam. Then written one later on 3/6, that is at date 19, madam. But it's a-
so their comments they have given.
they are-
So they have done it. Now, this was sent by how did you send it?
Well, this was sent by the courier. They have, and it was sent on 4th, madam.
Huh?
4th. They have said-
They send it by post.
madam,
How will it reach Cuttack?
madam, one,
Prayer to active students. Huh? Mr. How did you send it?
To courier as well as to me.
When was it received?
It's my material.
Ah.
28 is the, you know,
Page 25,
28, the last page, you know,
page 25.
20
Then,
25 is the letter, you know,
ah,
26 is the, you know,
page 25 is not the letter. Page 25, 23, 24 is the letter. Page 25 is the courier. And when was it received? You sent it on 4/6.
Can come to page, the last page,
Yeah.
27.
Ah,
This was, you know, the acknowledgement.
ah.
This is the acknowledgement letter number 7, so once it is received by the Assam for 4th. 30% to mail, 4th morning receipt. That's it.
Now, who signed here?
Now, worship, I just came to one thing, worship is recommended, refer to page 70.
Page 18. Ah.
Content.
Hmm.
No, worship is reported on 5th of June, that sequence that I can return back. We have received no documents from Assam FA in support of eligibility. If this does not mean that, you know, the documents were not received. Then because, you know, there was the condition, you know, for the purpose of the
Got it, got it, got it. The instant contempt application has been filed.
Well, they have changed the only the application to the email, not by documents, but the application, draft and all this were there.
Oh. See, this court, when they sought for modification, what was given is the application you send it, because there was already an order passed by the court, along with your comments. In their application, what they did, they forwarded the application. And the comment was, kindly don't allow them to participate as he is not eligible. And therefore, the endorsement which is there, that you participated out there, but there is no document as regards your eligibility. No, that this court is not going to.
The court has directed to send my application back. The board has directed to send my application along with all the documents with their remarks. They have sent the remarks. The letter is sent for the email, but they have not sent any documents with regard to my eligibility, my application form.
No, along with their eligibility, no document from AI in support of his eligibility.
No document is forwarded, madam. Only this letter, which is at page 17, is sent to the email, madam, not the document.
Hmm.
If they have got.
But what is the court's order?
The court order is to forward the application along with the.
Where? Which is along with what?
Page 15.
Yes. Petitioner's application.
Yes.
Then?
But the petitioner's application, not the letter, madam. I have submitted a separate letter.
The petitioner's application, not the documents. Has this court directed?
But at least my letter, madam, I have submitted my letter to allow me to participate in that course, madam. That
You
is
do
my
one
letter.
thing. You can fight it out in the trial court.
My submission is that, madam, my application is not that the letter at page 17, madam. I have submitted a separate letter, madam, along with the draft and all this are there, madam.
The court did not pass that order.
But the document identity is 15, madam, that's it. Page 15, madam.
I've seen it.
Yes,
It only says, doesn't say about documents.
Yes, you can forward the petitioner's application with their comments.
Then,
But this is the letter written by the Assam.
so your question is now that application shall include the documents also.
Yes, madam. No, but even they have not provided my application with the email, madam. Even my application is not provided with the email, madam. They have only sent the letter, madam.
Mr. Gupta, first of all, you have to understand that this is the contempt. The moment you point it out before the court, this court will see as to whether to draw proceedings against him or not. Thereafter, the matter ends on your part. Here is a case where the court passed an order. They, in compliance to that, have sent it. The application was sent. Now, can you say as to whether there was a willful violation in not sending the documents?
My submission is that, madam, on 2nd of June, the order by passed the decision of the court, and then in the miscase, madam. They waited for the third, their submission is that they have received the copy on third at 5:55. On fourth, my lord, they sent for the courier as well as email, but the email, what my instruction is that only the letter at page 17 was sent, not the application along with the document of the petitioner, which proves whether the petitioner is eligible to participate in this, for participating in this course or not. So my submission is that that is the violation of the court order, because the court says whatever is their remarks, whether I am eligible or not eligible, you send the application. And application contains all the details and particulars are also there. But they have not sent my application through the email, only the page 17.
Yes, Mr. Day, did you send the documents? Mr. Day,
That is not very clear, but.
not clear means I'm asking you, have you sent the documents?
Real below, because the real account, the real is.
Why did you send it on fourth?
Because it was received on 5:30 minute on third of. So morning 4th minute, we had sent it to courier.
So you knew about it on second.
So the way, no,
No, why do you need the certified copy for? Why do you need it? You had, this was passed in your presence. Then
on third minute, we received the certificate copy.
this order was passed in your presence, on your eye.
Yes, my lord.
Then you knew it, there was a direction to for you.
The lawsuit says, Jane was sent on third.
Where is that?
Page 27.
Huh?
Page 27.
Yes, what did you send?
This is the acknowledgement letter dated so and so, received the understanding by email on so and so, and it was sent on 3rd of June.
No. Produce the contents of your mail on the next. Produce the contents of your mail. But I'm telling you, if the contents of the mail does not contain the documents, which is a part of the application, whoever is the football secretary will be taken to task.
That point of view, presently we don't see it is not.
Huh?
Secretary, the order secretary.
No, because this will show that you have tried to do it. Now, who is now? Ankur Datta is not there.
He is not there. He belongs to that, lots of things have happened, Lord, even go to game, Lord, because it's a game also for some time. Lots of things have happened, Lord, this is of 2004, but in fact, I don't even have the address.
No, it's okay. Ankur Datta, you are paying for Ankur Datta. You are for Ankur Datta. You do and then what to do? You cannot produce that. Who is appearing for respond number 4 in that matter?
There are some people, yes, I think.
এই আবার তো রিকল করা না লাগে এইটুক দিন এখন you are appearing for respondent Mr. R.D., the learned counsel appearing on behalf of the respondent number 4 in the petition shall produce the email dated 4/6/2014 the email, the email which was sent to the All India Football Federation, enclosing therewith the letter dated 3/6/2014. This court had directed the Assam Football, the respondent number 4, to produce the said document to ascertain as to whether the said document, the document so filed along with the application by the petitioner was enclosed therewith, was attached therewith. The secretary of the Assam Football Association is further directed to file an affidavit bringing on record the said documents. List the matter again on 13th of October. You are appearing for the respondent number 4.
He was the honorary secretary, Lord, that's why.
No. First of all, what is there? It is already a 2014 matter. 13th of October.
13.
We are concerned with Assam Football Federation, 13th of October. You are having 2 weeks. Then what is wrong?
36.
Yes, who died? Substitution application, I think. Who died? Respond number 5. When did he die? Huh? 2018. Okay, issue notice making it returnable by 4 weeks. Steps by registered as well as users upon the opening parties.
37.
Yes, madam. Yes, madam, you are asking for going for paper publication. You then file your application. Miss So-and-so, the learned counsel appearing on behalf of the petitioner is given the liberty to file an application for seeking the permission, seeking the liberty of this court for paper publication. 4 weeks time is granted. No, 4 weeks time. They will come out of vacation. You file it, then it will come.
48.
Yes, service is complete. Huh? 38. No representation. None appears on behalf of the petitioner. Is it compliant?
Oh, but that's what you said.
Huh?
Whatever is.
None appears on behalf of the, but it is a contempt. I can't dismiss for default. What is there? Compliant. What's your name? So and so, the learned counsel appearing on behalf of respondent number 1 and 2 submits that the order dated 26/2/2018. 26/2 or what? Which order? 26/2/2018. Passed in WPC number 6715/2017 have already been complied with. In that regard, he has produced an instruction which is kept on record. Which is kept on record and marked with the letter X. Why? What is that? Huh? What is that? Contempt case so and so, Punitpur so and so Iman. With reference to the Iman raised by so and so, which is found to be in order, has been released. A copy of the said order is kept on record and marked with the copy of the said. And how much do you want?
Nothing, but interest are not, nothing.
Over.
Interest not paid at all.
Okay, how much else, how much amount is liable to be paid now?
That much, that becomes 5 lakhs, 40,390. That calculated in something.
You are entitled to some more amount.
Oh, that much.
The learned counsel for the petitioner submits that the amount of the principal amount have already been disbursed to the petitioner. However, the interest have not been paid. Mr. So and so, the learned counsel appearing for the respondent number 1, 2, and 3 submits that some more time is required for the purpose of making the payment, taking into account that the transport department, Assam State Transport Corporation is going through a financial crunch. So taking into account the above, list the matter again on 29th of November 2023, on which date the learned counsel appearing on behalf of the respondent number 1, 2, and 3 shall apply as to how much additional amount have been paid to the petitioners. Yes, Mr. Motel. Huh? It's a state of proceedings. My goodness. Stay of what? How? 420, 406, 506, why? Why? Understood, 226.2, but why?
Because your notice is empty. First of all, your notice no case is made out under section 16. It's purely civil dispute. And second, your notice entire cause of action, your notice in this case of Assam. They your notice.
Let us see their file.
Page 20.
I so and so, son of so and so, so and so, so and so, which was being manufactured at house of and then
last line was also kindly not. And then particularly paid for recovery of the outstanding, alleged outstanding dues or occupied.
State of disbursement or not. And formal.
What is the report? Service, okay, service being complete, list the matter on 11th of October 2023 at the top of the list. You dispose it of. Top of the list on the 11th of October. on the-
49.
Respondents have not filed any affidavit.
No, my lord, but out of 1,35,630 rupees, they have paid the outstanding dues of 42,950 and TDS of 30,650. The partner security by which by their demand of that they have distributed, they have said, they have changed in the affairs.
What is the direction passed?
In order to verify after instruction regarding non-encashment of the demand draft.
No, no, what is, no, where is the impugn order? The order by which,
Page 9.
according to this court, is inclined to direct the respondent to treat the uncertified delivery challan as valid under exception and so and shall carry out the exercise of verification claim within 1 month from the date of receipt of the certified copy of the and the outstanding amount, if due, shall be released by the petitioner within a period of 2 months. Now, how much amount has been released to you?
The outstanding amount and the TDS amount has been released to me. And the performance security which was given by the demand draft, that they are saying that they have given to me, that they will take party.
Now, was the demand draft encashed?
No, that's why that you are verified from the code, from the bank, whether that has been encased. I have given a copy of the yellow color flag.
There are so many yellows. Yes.
And this is 12/7/23
Unpaid.
unpaid.
So it is not encashed. So how will they pay you?
So they have not paid it. They have not disbursed the demand of the.
Have they used the demand draft?
They have taken the demand of.
Have they used it? Put to use you have given a demand draft. Where's the demand draft put to use?
So they kept it as performance security.
Understood? Did they use it?
No, they are saying.
No,
they have returned it. They have returned it.
So the question whether you say it has not been returned. So if it is not returned, he says it is being returned. Wouldn't that be a separate cause of action? Is it mentioned out there to return you the demand draft?
Yes, that's page 14.
Where? No, not here. Where's the order? We are concerned. This is the contempt. Is to treat the uncertified delivery challans as here. No. Where's the direction for demand draft? Where's the direction for demand draft?
Paragraph 3.
Oh,
Last slide. Paragraph 3. Or page 9.
yes.
Last slide.
Now, this is what the court has you mentioned.
Yes.
But whether the demand draft was that there is any direction or adjudication to the effect that the demand draft has to be returned to you. Where is that?
In total, 1,35,613.
Where is it? Paragraph 8 is the direction. And accordingly, the said respondent shall carry out the exercise of verification of the claim with regard to so and so from the Iman and if found due shall be released to the petitioner. If the dues is not released, then the state shall bear interest of 9%. Then where is the direction?
There are 3 components. One is outstanding due, another is TDS amount, and the other one is performance security.
Where is the purported security? Where is that? Where it has been mentioned in this order about the purported security?
This is my submission was made recorded.
That is your submission, where is the recording? The learning counsel for the petitioner submits that despite demand and error, the total amount still remains due. Where is the court's finding that the had merely stated they could not be paid due to non-submission of the year? There is nothing mentioned about the demand draft. Then it is mentioned.
But in the orders are from time to time. In this,
Time to time, lot of orders, lot of things are being passed. But the question is as to whether there is a direction. We are concerned about the content of an order passed by this court. Where is that order? That the demand draft is the question.
within all of these three companies, it comes to 1,35,690.
And there's a comma and say it found you another comma. Where do you take that? Huh? That is if there those three words were not there, these three words can help you.
By their own data, they are admitted. Page 14
Or
of this subject.
what do they say? With reference, I am hereby releasing the performance bank guarantee of so and so amount of rupees so and so only submitted by you against the supply of Iman so and so bank draft. So it is released.
Madam, and page 16, I am saying that only photograph of the demand draft has been sent.
Huh?
Only photograph of the demand draft has been sent.
So it is a question of fact. How can this court decide?
Now, this, that report says that it has not been encased.
So get the money from the bank. You see, what happens to a demand draft if it is not used? What happens? Just for example, you have purchased the demand draft. What happens if it is not used?
The name of some authority or any person.
Then what happens? Just for example, you buy a demand draft. You have to buy it from your payment. And for that, you are given a receipt. Once you buy the demand draft, and it is not being put to use, then what happens? And the period, what happens after that? FD keeps on accumulating. But what happens to the demand draft? Demand draft has a period, it cannot go beyond 6 months, or beyond 3 or 3 months, I suppose. Then what happens? We'll have it after vacations. List the matter after vacations. Just find out that. You want to file affidavit?
No, Lordship.
Oh, complied?
Yes, disposed of main petition is disposed of Lordship. So the vendor becomes infrastructure.
Why? List the matter after vacation. Let's see, because other side is not there. Without them, it won't be proper.
Okay, sir.
If you want. Service is complete. We'll have it for admission. There is urgency. Huh?
I want to pay another
Ah,
in the bank. Honor before 30.
okay, then we'll have it before vacation. Let's have it on the service being complete. List the matter again on 14th of on 16th of October.
15 lakhs before 30 of them.
30. That is why I'm having it on 16th of October.
I want to make the payment on or before 30.
Tomorrow.
No, 29,
30 October.
he wants to pay the amount before 29 October.
That is why I'm fixing it on 16th October.
I want to make the payment on or before 30 October.
13, 1-3. Then what is your problem when I have the matter on 16th October?
I want to see 30 October, not 1.
Did you say?
30 October.
After
want-
payment, you need to pay after payment.
And you have a fast one for it.
Oh, you want to pay and therefore I should fix it after that.
I want to make my payment before 30 October.
What do you want now?
I want to put the matter on again. First week of November.
The vacation.
After vacation,
Tell me that
follow.
this is the matter after the vacations.
Interest payment. Interest payment.
Ah, no. The service being completed, list the matter for admission on 16th of October. We'll see then,
This one and the two here.
we'll see. We'll give your names, it will be there. 52. Service being complete, list the matter of admission on 16th. Yes, the affidavit filed by respondent number 2 and 3. Service is complete. We'll have it for admission. Huh? Interim. I got the interim order be continued till the next day. The its service is complete. List the matter for admission immediately after the Puja vacations.
Yeah. By one day on sequential, and some amount was also sanctioned, but later on, against only one, some amount has been sanctioned, that may be seen by the 11 and 20.
So you want to continue or not?
The positive means that they have said we have allocated and taken, but money is not delivered, that is only.
They have not paid the money.
Not paid.
Okay, we'll take it up after vacation.
So they have said that we have only 5 and 9 of the.
No, but other side being not represented, it may not be proper. Is the matter on, do you want it on another date?
Next week.
Next week. Let the matter be listed on 18th of October. Liberty is given to the petitioner to mention the matter for upgrading. Yes, complied. Okay. The learned counsel appearing on behalf of the sole respondent submits that the order has been partly complied with and further steps are being taken in that regard. As such, he seeks for an accommodation of 4 weeks in this regard. List the matter on 29th of November.
55.
Six two. 55 two. No, service complete only. हल्के नीले खिले के नहीं गया वो सर्विस तो होते नहीं. It is not clear from the order passed by from the office note as to whether the service is complete. List the matter. The registry shall take due note of the same and place the matter for orders. And place and list the matter accordingly before this court.
56.
Okay, you have filed your affidavits.
Yes, I will, yes. After reply also, but everything,
It's okay. No affidavit in opposition has been filed by the section. When did you file?
from that time. They have been started copy of reply also to me, Madam Devi, for yesterday.
Then why this authority they have written? Who has not filed affidavit? State council has not filed. Who are you? Huh? State, you are filing your affidavit or not? The state of Assam is granted 3 weeks time for filing the affidavit. List the matter again on 23rd, 24th, 22nd of November 2023 for admission. In the meantime, the state of Assam shall file the affidavit without appeal. Here's that item with where is the personal appearance of that by video conference?
And was 71.
Very good.
71.
Click you, Lalit.
I do it.
71, yes. Where is that? 2%. Next question is the bailable warrant.
71.
Well, have they given the link? You have provided the link? The PNRD is not there. What is your stand, Mr. Dubey?
But there is a guideline.
You have not enclosed the guidelines?
No, it is there in the regulation itself.
What is it? No, what is your stand out here? Submits,
So it's stated.
provides for reservation for the office of the president in more particularly and speaks reservation to the tenure, including the number of officers and so and so. We stated herein that Rule 61 was incorporated with effect, and for the sake of brevity, the contents of Rule 61 are not treated herein and correspond with the liberty of consider stated the circle through and provides the so the bigger things should be reserved for any law. So you say that you have nothing to do.
We have framed a guideline.
You say that you have nothing to do. See your paragraph 4.
Yes, we have issued guidelines in terms of.
You have no
They have to do that.
power.
No,
No, you have no power.
we prescribe the method in which it has to be done, and the exercise has to be carried out by them in terms of the guideline.
You say in paragraph number 4 that you have no power to enforce your guidelines. Read it, paragraph 4. Yes, Mr. Devnath, what happened? No, what, this person is waiting. If you want, he can help you out. He has already, I think the link must have been given. Got it? Have you sent the link? Send the link. Because in paragraph number 4, you see that you have some guidelines, you have some rules, but you can't do anything. It is the state who has to explain what has happened, what. Yes, kindly see. Kindly see the last paragraph number 4, the last part. In the present case, how and in what manner the power has been exercised by the state government in the panchayat and rural development, while considering reservation of seat of president so and so is a matter within the domain of the state government, as it had to consider various factual aspects of the matter, and therefore it is the state government in the panchayat and rural development who can explain the exercise done by them while issuing the notification. Depending upon the explanation of the state government, this court can determine whether the state government in the panchayat has flouted the provisions of the act and the rules made thereunder, and the guidelines of so and so notified in so and so as alleged by the petitioner in considering or not considering reservation. Meaning thereby you say that we have nothing to do, we only issue a guideline, whether they follow or not, or we are not bothered.
I have to kindly see an actual fee of the reputation.
What do you mean by this paragraph?
Or
Your paragraph, which I could understood in simple English language, is that we have made a guidelines. There is a provision. Whatever they do, the state government will do. We have no power to enforce our guidelines. Or even take into account the provisions of the constitutional amendment, as well as the amendment, not in the constitution, the amendment, the provisions of 70A, as well as Rule 61. We have no power.
13(1) is an enabling provision by which we have put a guideline and we have laid down certain
What happens if your guideline is not followed?
consequences have not been given.
So your guideline is without it. That's it. So we are to understand your guideline in view of paragraph number 4, Mr. Gustame, that these guidelines are without any teach. It is useless. The question, however it is,
Here, the limit of the state below, that Environment has not followed that guideline. Last paragraph. it starts at Paragraph 4, 2, that is 38, third line. It
as raised in the present so far as the role of the state is concerned. It is stated and submitted that the basic grievance is that on the basis of review so and so, read with AR, there under notification, read with Iman, the post of the president mayor ought to have been reserved for a woman after the election conducted in 2000 in Iran, and since the notification issued by the principal secretary Panchayat and Iman did not reserve the seat for a woman, the same needs to be modified.
what the prayer is by the petitioner.
Where is it? Why do you say? It is stated. Kindly come to the third line of page 38. It is stated and submitted. That is your thing. That the basic grievance of the petitioner is that on the basis of so and so, so and so, so and so, as Iman issued, the post of the president ought to have been reserved for so and so and so and so, Iman. The president submits that section 70 area. So you have said nothing. Your affidavit only says that you have no business. You cannot do anything. You have no power. We'll record it. The affidavit In quote paragraph 4 that you have
That has to be
noticed.
read along with the
What notice?
notification that has been challenged by the.
What challenge notice here? You say that you have nothing, no power. Is this the state of affairs of Assam State Election Board, Assam State Election Commission? We know that the Assam State Election Commission is under the state government or under the aegis of this government. Are we to understand that you are under the aegis of a political parties? Then what is this?
My lord, kindly see.
No, why you are not taking a proper stand? Show me. What have you done at Annexure 3? Let's see. What is it? Notification. No, this you have not issued.
No, that state government is strategically advanced.
No, I am not concerned with that. What guidelines you have issued?
Yes.
Where?
Other than stage 15 or also.
Page?
15.
Yes.
Stage 12.
Reservation of post of president and vice president. The state government of Assam PNRDD will do the reservation of the office of the president and so in accordance with so and so. It is to be noted that while doing the reservation for asset, the whether principal be issued and so and so. The Jila Parishad where the office of the president has been reserved for the scheduled caste or scheduled tribe, the office of the vice president shall not be reserved for scheduled caste or scheduled tribe. The state government shall notice that. So, but this is you without any, you have noted.
That while working out this, they have to.
No, like I'm telling you, like the Election Commission of India has the power to enforce. The State Election Commission has no power. This court. Yes, Mr. Devnath, this court can't keep on waiting. I give you time for filing your affidavit. File your affidavit by 6th of October. And else let the commissioner and secretary be personally present. Huh? No, this is the important question because here the state, no, Assam State Election Commission puts the blame upon you absolutely. Meaning thereby that you have totally, the petitioner clearly says, State Election Commission also says that it is your mistake. Huh? Okay, we'll have it on 11th. You file your affidavit, else he appears. There's no. This court, by an order dated 13/9/2023, directed the Assam State Election Commission as well as the PNRD department to file their affidavit, and failing which appropriate directions shall be passed for personal appearance of the Chief Electoral Officer of the Assam State Election Commission, as well as the Commissioner and Secretary to the Government of Assam PNRD Department on such date as may be fixed by this court. Pursuant to the said order, the Assam State Election Commission has filed an affidavit wherein the stand could be seen from paragraph number 4 of the said affidavit, which is quoted here in below, page 40. From a perusal of the said quoted paragraph, it seems that the Assam State Election Commission admits that it is toothless in complying, toothless to enforce the guidelines which have been issued on 25/10/2017 and places the entire burden upon the Panchayat and Rural Development Department. It is also relevant to take note of that in spite of the order passed by this court on 13/9/2023, neither any affidavit has been filed by the PNRD department, nor any instruction was produced by Mr. N.K. Devnath, the learned counsel for the standing counsel for the PNRD department. Under such circumstances, in view of the specific stand taken by the State Election Commission, Assam State Election Commission, who admits that it has no authority. This court directs the Secretary to the Government of Assam, Panchayat and Rural Development Department to file their affidavit by 13th of October 2023. The matter would be taken up on 16th of October 2023. It is made clear that if the affidavit is not filed on 13th of October 2023, the Secretary to the Government of Assam, Panchayat and Rural Development Department shall be personally present at 10:15 a.m. before this court.